Good morning, folks. We'll convene the Standing Committee on Public Accounts once again today. We'll turn our attention this morning to the Ministry of Justice and Attorney General, Sask Legal Aid Commission, and so on. At this point, I'd like to introduce some substitutions around the table, as well as I'll start with the committee members. Our Deputy Chair, Ms. Young, Mr. Hugh Nerline, Mr. Delbert Kirsch, Mr. Todd Gowdy, Mr. Marv Friesen, Mr. Dana Skoropad. In place of substituting for Ms. Alina Young is Ms. Erica Ritchie. And substitutions for the Provincial Comptroller's Office for Terry and Chris, Terry Payton and Chris Beda. We have Sandra Steppen and Kristen Walker. Welcome to the table. It's nice to have you here today. Thank you for being here. I'd welcome and introduce our Provincial Auditor, Tara Clement, and officials in attendance here today. I know she'll be introducing the officials relevant to each chapter as we go. And it's a pleasure to welcome from the Ministry of Justice and Attorney General, Ms. Head, the Assistant Deputy Attorney General, as well as officials with the Ministry of Justice who have joined us here today. Thank you so much for joining us. Ms. Head, I'd turn it over to you to briefly introduce the officials that are with you here today. Reserve any other comment for now. We will then turn it over for the report from the Provincial Auditor, and then you'll have a chance to offer a remark with respect to those chapters.
Thank you, Mr. Chair. So to my left here, we have Monica Field, who is the Executive Director, Strategic Systems and Innovations. We're going to have different people coming up and speaking to each chapter, so I'll just introduce the crew for now. But we may reintroduce people as they come to the front, just so you know who they are. I think that would make sense. So seated behind me is Shannon Williams, Assistant Deputy Attorney General with the Justice Services Division. I believe we do not yet have Jan Turner with us, who is an Assistant Deputy Minister of Court Services Division. She did have a meeting from 7:30 to 8 this morning, so she warned me she may be a little bit late, but she is coming. As well, we have the Chief Executive Officer of Legal Aid Saskatchewan, sitting sort of in the back of the room, Jane Mallon, and the Director of Planning and Administration with Legal Aid, Kyla Shea, seated next to her. Over behind my left shoulder, we have Carolyn Decker, who is the Deputy Public Guardian and Trustee, and Anne-Marie Cotter will be joining us as well. I believe she's not here yet. She's the Director of the Office of Residential Tenancies. And so my name for the record is Kylie Head, Assistant Deputy Attorney General. Just pass on regrets from the Deputy Minister, Glenn Gardner, who's not able to be here with us today.
Thank you very much, Ms. Head, and thank you to all the officials for your work day to day and for being here today. I'll just table. I'll table the document pack 4929, Ministry of Justice and Attorney General status update dated March 2nd, 2022. And I want to thank everyone that was involved in completing that status update, showing the work that's been undertaken. It really allows us to focus our questioning and be efficient and effective at this table. So thanks for doing that. What we'll do now is we'll ask the provincial auditor to make presentation on the first two chapters, which are going to be dealt with together, and those would be both Chapter 8 of the 2019 and 2020 report volume 2s, respectively.
Thank you, Mr. Chair, Deputy Chair, other committee members and officials. With me today, behind me is Kim Lowe. She's the liaison with this committee for our office, and she will be doing a presentation later on. I also have seated beside her is Jason Shaw. He is one of our new Deputy Provincial Auditors, and he'll be doing a presentation later as well. And then to my left is my other new Deputy Provincial Auditor, Jason Wandy. And so he's now responsible for the Health Division, but used to be involved in terms of the portfolio of work with regards to the Ministry of Justice and Attorney General. So Jason is going to basically walk through in the order of the agenda before you with regards to the Ministry of Justice and Attorney General. As the chair indicated, he is going to present the first two chapters together. He will pause for the committee's consideration after every presentation. There are no new recommendations for the committee's consideration. I do want to thank all the ministry officials for the cooperation that was extended to us during the course of our audit work. With that, I'll turn it over to Jason.
Thank you, Tara. So the first two chapters, both from Chapter 8 from our 2019 and 2020 reports, Volume 2, report on the annual integrated audit results of the Ministry of Justice and Attorney General. We also provide an update in our 2021 report, Volume 2, Chapter 14, which includes a summary of implemented recommendations. Our integrated audits found that the Ministry had effective rules and procedures to safeguard public resources and complied with the relevant authorities, though both chapters included a finding related to removing unneeded user access. The recommendation was first reported in 2015, and we provided updates in both the 2019 and 2020 chapters. We continued to recommend the Ministry of Justice and Attorney General follow its established procedures for removing unneeded user access to its computer systems and data. Not removing unneeded user IT access promptly increases the risk of unauthorized access to IT systems and data, including confidential information, along with an increased risk of inappropriate modifications to IT systems or data. We provide an update in the Summary of Implemented Recommendations chapter included in our 2021 report, Volume 2, Chapter 14, on page 80. During the 2021 fiscal year, the Ministry developed a timely removal from information technology systems policy, which outlines when the Ministry expects a user's access to be removed and defines what is considered timely removal, that is, within 3 business days. We note the Ministry is continuing to reduce the number and severity of instances of late user access removal. They continue to work with the Public Service Commission to receive notifications when staff leave the Ministry. We do not consider the identified deviations to be significant, and we confirmed accounts were not inappropriately accessed after the users ceased employment with the Ministry. We consider the intent of the recommendation implemented. I will now stop for the committee's consideration.
Thank you for the focus of the work and that presentation. I'll turn it over for a brief comment from Ms. Head and then open it up for any questions.
Thank you, Mr. Chair. So I would just add that the Ministry has done extensive work to get this recommendation implemented, which includes developing a timely removal from information technology systems policy, which outlines circumstances when the Ministry expects a user's access to be removed and defines what is considered timely removal. which for us is within 3 business days. The ministry continues to work with the Public Service Commission to receive notifications when staff leave the ministry. And as has been noted by the Auditor's Office, it is considered that this recommendation has been implemented as reported in the 2021 report, Volume 2, Chapter 14.
Thank you. Thank you very much. Thanks to all that were involved in the work on the implementation on this front. I'd open it up to committee if there's any questions. Ms. Ritchie.
Thank you, Mr. Chair. I would just note in the 2019 report on page 16, and I think I heard correctly, but I just want to confirm what I heard in terms of the implementation. But it does state that in 2018-19, the Public Service Commission started to notify staff at Justice when employees no longer worked at the ministry, and management know this process will help them improve timeliness for moving access. So are you saying that process is in place now, or I could, and you're nodding, okay. That was my understanding, but I just wanted to clarify. Thank you.
Thank you very much. Any other questions, committee members? Not seeing any, I would ask for a motion to conclude consideration of both these chapters. Can we make one motion for the 2 of them? So that would be for chapter, the 2019 report, volume 2, chapter 8, and 2020 report, volume 2, chapter 8, that this committee concludes consideration. Moved by Deputy Chair Young. All agreed? That's carried. We'll move along now to chapter 37, and I'll turn it over to the Office of the Provincial Auditor.
Chapter 37 of our 2019 report, Volume 2, reports the results of our 4th follow-up of 2012 recommendations we made on the ministry's processes to enforce maintenance payments. Families depend on the timely receipt of maintenance payments. There were 2 outstanding recommendations. By September 2019, the ministry implemented both outstanding recommendations. We found the ministry requires its maintenance enforcement officers to review and document actions taken to enforce defaulted maintenance payments. Officers do this review every 2 months, and it allows them to keep accurate and up-to-date information. It also allows them to monitor the actions taken to enforce payments and adjust actions as needed. I will now pause for the committee's consideration.
Thanks for the follow-up work on this front. Again, just to all those folks that are tuning in from home, I think our viewership is big today. I just want to remind folks that we've already considered all these recommendations and had lots of questions, and this is the follow-up then by the auditor. I'll turn it over to Ms. Head for any quick comments on it, and then open it up for questions.
Sure. Thank you, Mr. Chair. So you're absolutely correct. This is the 4th time that this item has appeared here at the committee and for the follow-up audit. Having up-to-date payer information helps facilitate appropriate enforcement action on payers who owe maintenance enforcement payments. Periodic reviews of outstanding maintenance enforcement payments helps the ministry monitor how well enforcement actions work and make any adjustments as necessary. The review of the reports continues to be a critical component of case management and enforcement actions as it enhances the collection of child and spousal support. As noted by the Provincial Auditor's Office, these recommendations are now fully implemented. So I would just ask if there are any questions.
Thank you so much. Thanks for the work on this front. Questions from committee? Ms. Ritchie.
Thank you. Yeah, just a couple of follow-up questions regarding how well that system is working. Can you tell us what has been the experience in undertaking those enforcement actions, how well they are being implemented?
So I'm going to introduce again here for you Shannon Williams, who is Assistant Deputy Attorney General with the Justice Services Division.
Thank you for that question. I can indicate that these mechanisms, as we've indicated, the reports are being issued every 2 months, and the officers are reviewing those reports. They're looking at what payments are still outstanding and what arrears are in place, and they're reviewing those with their managers every 2 months. So those reports are being indicated, and they are doing collections based on those reports. So we have one of the highest collection rates in the country for our arrears. So our collection rates are anywhere between 88 to 91%. So I can say that the methods that have been implemented have been very effective in terms of collecting these arrears, and we're continuing to see those types of rates.
And has there been any uptick because of COVID, or just wondering what sort of the average number of cases you're dealing with on a month-to-month basis?
There's still, I think our average cases have stayed fairly stagnant, so we're seeing the same amount of cases quite regularly. I can say that throughout the pandemic, 90% of our maintenance enforcement staff stayed in office and continued the work that they were doing. So they were not individuals who were able to work from home. So this is obviously, a difficult position, and they deal with very difficult cases, and we very much commend them for the work that they do. But what I can say is that through 2021, in the first year of COVID, our maintenance enforcement office collected $1 million more than they did in the 2019-2020 year. So we're seeing even more collections in the last year through the pandemic, which I think was somewhat unexpected, but it is what we saw this past year. And I think that's due to some of the good work of the people that are doing that work and their resilience throughout this pandemic. But also I think it's just based on the the follow-up that we're getting from some of these reports that we're looking at and the work that they're doing in terms of following up on the arrears that are outstanding.
And can you tell us how many cases, though, that you're dealing with at any point in time?
Each maintenance officer has a caseload of approximately, it depends, but around 450 cases, and that has been stayed the same throughout at least the last 5 years. So each officer has around that many cases, and we're having different, every month we get so I think they said there's approximately, right now, we have approximately 8,000 case files where we have arrears on them right now. So, and that they're collecting on, but each officer themselves has approximately 450 cases that they're dealing with themselves.
Thank you. No further questions.
Thank you. Thank you very much for the questions. Any other questions from committee members? Not seeing any, I'd look for a motion to conclude consideration with respect to Chapter 37, moved by Mr. Nerline. All agreed? That's carried. We'll move along now to Chapter 33, and I'll turn it back over to the Office of the Provincial Auditor.
Thank you.
Chair, if I could interject, I think Assistant Deputy Minister is still not present. So would it be possible to change the order of the agenda just to allow her to be present for that conversation?
We certainly can adjust our agenda. Thanks for flagging that. Would we then be able to roll in, would it make sense, into the Legal Aid Commission at this point? Does that work for your officials?
Mr. Chair.
And is the committee agreed to amend the agenda? All right. So we'll come back then to Chapter 33, and we'll focus our attention now on the Saskatchewan Legal Aid Commission, which will be Chapters 41 and 34 respectively, and I'll turn it over to the Office of the Provincial Auditor.
So with me for this presentation is Mr. Jason Shaw, Deputy Provincial Auditor, who was responsible for the audit of the Saskatchewan Legal Aid Commission. He's going to present the chapters on the agenda. In this instance, they'll both be combined together into one presentation. And before he does begin, I just want to say thank you to the Chief Executive Officer and her staff for the cooperation that was extended to us during the course of our work. With that, I'll turn it over to Jason.
Thank you, Tara. Chapter 41 of our 2018 report, Volume 2, starting on page 275, and Chapter 34 of our 2021 report, Volume 2, starting on page 247, reports the results of our follow-up of recommendations we initially made in our 2016 audit of the Commission's processes to provide legal aid services. The Public Accounts Committee agreed with the original 5 recommendations on January 11th, 2017. Timely access to legal aid services improves the effectiveness of the justice system. For example, effective legal aid services may reduce time a person is held in custody, may resolve cases faster, and may provide protection, such as obtaining a restraining order sooner. By August 2018, the Commission had implemented one of the 5 original recommendations. By August 2021, the Commission had implemented a further 2 recommendations. The Commission updated its policies and procedures guiding the provision of legal aid services and obtained the Board of Commission's approval for its key policy revisions. Having up-to-date policies and guidance provides staff with clear direction and expectation and reduces the risk of staff providing services to ineligible clients. The Commission set 2 new measures related to assessing the quality and timely delivery of its legal aid services. For example, it targeted that Commission staff would answer 85% of client calls to its application center within 2.5 minutes. Setting clear expectations for delivering timely and quality legal aid services helps the Commission determine the extent and resources needed to reach desired results and address inhibiting factors. Finally, it published reasons for key differences between actual and expected results for its client service standards. It also published its planned actions to improve legal aid services in its annual report. Publishing reasons for key differences between expected and actual results provides legislators and the public with useful performance information. The Commission was working on implementing the remaining 2 recommendations at August 2021. Starting on page 249 of our 2021 report, we noted the Commission made progress toward consistently keeping information in its electronic case management system accurate. However, we found instances of criminal and family cases not closed in the case management system in a timely manner. For 3 of 30 files we tested, the Commission did not promptly close its case files, ranging between 30 and 191 days after the last court date. From testing 30 additional files, we found an additional 9 files closed later than expected. Not closing case files timely inaccurately reflects lawyers' caseloads and increases the risk of ineffective monitoring, as well as not properly allocating resources to the right places at the right time. On page 251 of our 2020 report, the Commission performed staff probation performance evaluations and developed a performance management policy. However, it had not yet extended staff performance evaluations beyond staff's probationary period. Since our 2016 audit, the Commission developed a performance management policy that sets written guidance and frequency for staff performance evaluations. The Commission did not undertake any annual performance reviews in 2020. By August 2021, the Commission developed an annual performance review standardized form and began its annual performance review process for staff lawyers. Doing written performance evaluations gives feedback on the quality and timeliness of legal aid services provided by staff lawyers. Also, evaluations can provide a supportive culture of professional engagement and enable timely coaching of staff on areas identified as needing improvement. This concludes my presentation. Thank you.
Thank you for the presentation and all the follow-up work. I'll turn it over to Ms. Head for brief remarks, and then we'll open it up if there's questions.
Thank you, Mr. Chair. As 3 of the 5 recommendations have now been implemented, I will speak to the remaining 2 recommendations with a status of partially implemented. Regarding the recommendation to conduct written annual performance evaluations of its lawyers, the Commission is making good progress. The first set of lawyer performance reviews took place in August and October of 2021, and a full set of performance reviews are targeted to be completed by May 2022. We developed a framework for performance management, including a process for progressive discipline and performance improvement plans. Directors and managers received training on performance management, coaching, and mentoring. For the recommendation to use the electronic case management system to capture accurately the status of legal aid cases in a timely manner to facilitate monitoring of lawyer caseloads, in December, the Commission has developed and communicated a policy to its staff to have all files closed between 30 to 45 days after the last court action. Management runs reports on a quarterly basis, and the Director of Operations meets with the legal directors each quarter to review performance. Management will be conducting spot audits of the file closings to ensure that lawyers are compliant with this policy. I would just like to introduce here for you the CEO of Legal Aid Saskatchewan, here seated to my left, which is Jane Mellon. Jane is still fairly new to her position. We've stolen her from Ontario. We're quite pleased with our acquisition. She's been doing an absolutely wonderful job taking over as CEO of Legal Aid Saskatchewan. She's been there now for 6 months and has been working on these recommendations since her arrival. And seated behind us is Kyla Shea, who is the Director of Operations with Legal Aid Saskatchewan and has been actively working on a lot of these improvements. And we would just like to thank the Auditor's Office for coming in and flagging these issues with us, and we're working away on responding and making those improvements.
Thanks so very much, and welcome, Ms. Mellon, as the Chief Executive Officer. Welcome to Saskatchewan. Thanks for your leadership to Saskatchewan people through the Saskatchewan Legal Aid Commission, such an important organization and role and service. So thank you very much. We'll open it up to the committee for questions. Ms. Ritchie.
Thank you, Mr. Chair. I just want to start by asking how many people have applied and being denied legal aid in the past year since the audit?
I'm sorry, I don't have that information readily at my fingertips. I can get that information for you.
Yeah.
Maybe just on that, just so I'm consistent when there's undertakings, thank you very much for that undertaking. If you can supply that information back through the clerk, it'll then get supplied officially to all of us around this table.
Thank you, Mr. Chair.
And yeah, I appreciate, especially, welcome to Saskatchewan, and I'm sure you're busy getting up to speed in your role, and will have need to go back and gather that information. I did have a follow-on question, though, in terms of since these changes been made, how has how has this changed since the central intake system was implemented? And again, I'm not sure if you're able to speak to that, but it's my understanding, again, only just sort of peripherally in terms of how, cases are being received through the central intake, and wanting to understand how that's changed in the ability for people to receive access to legal aid.
Yeah, my understanding is the central intake system has improved our ability to respond in a timely fashion, and that our intake, our calls typically are answered within 2 minutes, and people are being given responses within 2.5 to 4 minutes. And so it's a fairly quick turnaround for our clients, and we're really proud of that. We do know that there are some issues where there needs follow-up, but for the most part, our clients are provided with service fairly quickly.
Well, that sounds like a very fast response time. I think it has more to do with, once received through that intake system, how they're then being processed and whether or not they're being approved to receive assistance. How has that impacted any at all?
So the approvals are in the moment. That most people know within a few minutes whether or not they qualify for our services. It's that quickly. And then time to first appointment has also improved. We know that time to first appointment was being calculated differently in different offices, and so we're working with our legal directors to standardize that, to make sure that when the information goes into our system, the date the person actually speaks with their lawyer in the first time is properly documented. But my understanding, and if I could ask my Director of Operations and Planning, she probably has a bit more detail about that process and those numbers, but my understanding is there's been significant improvement.
And appreciating both the fact that this isn't the first time the questions have come to committee or the recommendations, and they're probably, our justice critic would know these matters far better than myself. But I would like to just ask the question in terms of with making those assessments, what the basis for them. If you could please explain that.
One of the recommendations the provincial auditor had made was to standardize our set of policies around eligibility. As a result, we developed an organization-wide eligibility manual, which was much more detailed than we'd had in the past. As a result, the eligibility decisions are much more consistent across the organization. So if you apply in La Ronge or Battlefords or Estevan or with the application center, you get the same decision. And that wasn't always happening prior to the provincial audit and the development of this policy. So that did make some changes, to the denial rate, but what it did result is in consistent decisions. It also meant that the applicants stopped office shopping. So what would happen is someone would be denied in one office and then apply at multiple other offices to see if they could get service there.
Okay, thank you for that, and appreciate that follow-up information in terms of the stats since its implementation. Just some questions about the cost of implementing this system. For timekeeping, is this an automated system? And
so we, in 2011, developed a case management system for legal aid and working with a local programming company. What we've done is we've added the ability to track time to the existing case management system. So the actual IT costs were very minimal. And to be clear, we've also then turned around and licensed the system to the Northwest Territories Legal Aid, which has allowed us to recoup a portion of costs as well. So they're actually also using our case management system now.
Is there, just a question in terms of, are you relying on the legal aid lawyers themselves to undertake these assessments and do the data entry? How is the system used by the office?
Keeping system. So there's a couple of different ways that it's used, and it really depends on the lawyer. So for lawyers that are, a little more tech savvy, a little more comfortable with technology, they're in our case management system, creating their letters, updating the client information, putting in their notes already. So they're just adding time when they're in there. They're already there. They're in the case. It's 2 clicks to add some more time to that. Or other folks, they are making notes on our standardized templates, which also are a result of the provincial auditor's recommendation. And so then the data entry can be done from those standardized templates. We do encourage the lawyers to do their own time entries because otherwise they feel they have to go back and check the data entry, and that just creates extra work because then you have admin work to do the data input, and then we also have lawyer work to double check it. We're in the process of implementing some updates to that time recording that should be active for April 1st of this year. And again, we'll mimic some of the features of commercial products like PC Law.
Well, I won't claim to know what that is, but I get the concept. Thank you. And just one final question. So will offices see an investment in staff support to help with file management, timekeeping, any of these kinds of things?
Sorry, did you want to?
Yeah, no, I was going to say, we have actually just announced a number of new positions COVID relief positions. Our staff have been overwhelmed over the last couple of years with COVID, with the pandemic, as you can imagine, appreciate. They have been incredibly resilient throughout that process, but we wanted to provide them with the appropriate support as we get back to the new normal and as courts get back into a regular routine. And so we have announced, I think it's 7 new positions. 5 of them, 8. 5 of them are lawyer positions and 3 of them are administrative positions. So 3 of them will go into our, 4, 9. Sorry, apologies, 9, because we have 5 lawyer positions and 4 admin. 3 of them will go into our eligibility office to increase, again, our effectiveness and efficiency at the front end when we're taking application, and then an admin support in one of our local offices that was short on admin. So the lawyers themselves will be expected to do time docketing and keeping track of that time, but they'll have supports in other ways.
And how did you arrive at those numbers in terms of lawyers and admin staff? What was basis?
We looked at the caseloads in each area office and the ratio of admin to lawyers, and we made those decisions based on those numbers.
And what is that ratio?
We have 1 admin for every 2 lawyers, essentially, in the offices, depending on the volume. And there are some slight differences, and perhaps Kylie, you could speak to some of those variations, but essentially that's what it is.
Yeah, there is a bit of a difference between a smaller office, like our smallest office has 2 lawyers, and our largest office has 16. So there is, some different processes in place. So staffing is looked at a little bit differently.
In terms of the ratios for lawyers to number of cases, how is that set?
Lawyers carry between 60 and 100 cases, depending on the type of law. Family law, it's a lower caseload. Criminal, a little higher, but that's essentially the range, is 60 to 100. And that the legal directors are tasked with workload distribution and making sure those workloads are fairly distributed.
Okay, thank you very much. No further questions.
Thank you for the questions. Thanks for all the work on these fronts. Any further questions? Deputy Chair Young?
Based on the staff performance evaluations that you have partially implemented, are there any lawyers on probation currently?
All of our lawyers are subject to a probationary period of 9 months. So legal aid always had a probationary evaluation process. So there was an evaluation at the halfway point and at the end of the probation. And then what was implemented was the performance evaluation piece. As a result of those performance evaluations, there are some performance improvement plans in place. They're no longer probationary because they're they're permanent lawyers now. But there are performance improvement plans in place as a result of those performance evaluations.
How many of those would be on a performance evaluation?
I can get you that number, but I don't have that number off the top of my head. Thank you. Sorry. I should also, if I could, just say that we do consider that recommendation complete. We'll be happy to meet with the auditor when they return. All of our performance evaluations have been conducted as of now.
Thanks again for the work on this front towards implementation. Really appreciated. No further questions at this point. We're not seeing any. I'll welcome a motion to conclude consideration of chapters 41 and 34 pertaining to the Saskatchewan Legal Aid Commission. Deputy Chair Young moves. All agreed? That's carried. Now I'm just checking. I think we have the officials in the room that we need to adjust our agenda here. So are folks okay to amend our agenda and go back to Chapter 33 with the Ministry of Justice and Attorney General? All right. We'll do that then. So I'll turn it over to the Office of the Provincial Auditor, and we'll turn our attention to Chapter 33.
Thank you, Mr. Chair. The last Ministry of Justice and Attorney General chapter is Chapter 33 of our 2020 report, Volume 2. This is our second follow-up on the Ministry of Justice's progress in implementing the 5 recommendations remaining from our audit of its processes to support the provincial court in managing court workloads. The right to timely delivery of justice is covered under the Canadian Charter of Rights and Freedoms, and the Supreme Court of Canada has set out reasonable timeframes. The Ministry of Justice supports the Provincial Court to effectively manage work pressures and wait times so delays do not exceed the 18-month ceiling and cases are completed in a reasonable period. The Ministry implemented 3 of the 5 remaining recommendations. We found the Ministry developed performance measures and set related targets. It made public its key action plans to address operating pressures related to supporting the management of court workloads, and it implemented a human resources plan that includes up-to-date procedure manuals. The Ministry developed a forecasting model to support the management of court workloads. However, it still needed to implement this. We also note the Ministry improved its collection of information related to its key performance measures. However, it still needed to analyze, monitor, and report on them. Implementing its forecasting plan will support the management of court workloads and can help reduce unnecessary overtime and timely scheduling of the court's hearings. Improving its analysis and monitoring of performance information will help the Ministry improve its understanding of key factors that influence workloads. I will now pause for the committee's consideration.
Thank you very much for the follow-up and for that presentation. I'll turn it over to Ms. Head for a brief presentation, then we'll open it up for questions.
Thank you, Mr. Chair. Regarding the first 2 recommendations, the provincial auditor has noted that these are now fully implemented, so we'll focus on the remaining recommendations. Regarding the recommendation to develop and implement a complete forecasting process that identifies administrative and financial resources needed to support the management of court workloads, the Regina and Saskatoon provincial court offices will participate in a financial forecasting pilot this spring 2022, with a projected rollout to all provincial court offices in January 2023. Administrative and management components of the forecasting model will be developed during spring 2022, with the pilot targeted for December of this year. The Ministry expects full implementation of both components by October 2023. The 4th recommendation is reported by the provincial auditor as fully implemented. And then for the last recommendation, to improve the collection, analysis, monitoring, and public reporting of information related to supporting the management of provincial court Saskatchewan workloads, quarterly analysis, including the process for engagement of key stakeholders, of the 5 performance measures will be provided to Ministry senior management by April 2022. Monthly and quarterly reporting of the 3 performance measures related to court data will be included in a prioritized Ministry initiative, the Strategic Dashboard, for access by the court and external key stakeholders by July 2022. So we have everything underway to have these recommendations addressed.
Thank you for the presentation, the work on this front. Thanks as well for detailing that in the status update that we have. I'll open it up to committee members for questions. Ms. Ritchie.
Thank you, Mr. Chair. On page 254 from the 2018-19 data indicates that the length of time to case resolution had been set at 259 days. Can you provide updated numbers for 2019-20 and 2020-21, please?
So I'll introduce here to my right is Assistant Deputy Minister Jan Turner, who is the Assistant Deputy Minister of the Courts Division.
Okay. Good morning, and I feel I need to apologize for arriving late. I had another commitment that I couldn't change this morning, so I'm sorry about that. I don't have the exact number in front of me today. I think you can appreciate that the last 2 years in courts has been exceptional, to say the least, and that there has been a lot of factors. But I will note the question, and we will certainly get that information forward.
Thank you for that. Is there anything further you could say about how these backlogs are being managed?
Maybe I'll start with the numbers. How's that? And let you know what's actually occurring in the court right now. Historically, if we look at 10 years within provincial court, and I'm only going to speak about provincial court today because that was the subject of the review, we do about 1 million appearances, which is one of the numbers, one of our key numbers that we look at. And in the last year, so just concluding 2021, we actually heard 1.2 million appearances during that time. And so this has been escalating. And in fact, if you look back 10 years, and that's probably too much of a comparative, the workload of the court has doubled. It's 50% more than it was 10 years ago. So those matters have been increasing as well, even during this very exceptional time that we have. One of the things that I would like to talk about today, and I think there'll be questions, is how we're managing our overtime in managing all of that. And I think we have a good story to tell on that particular front. So it has been a balance, and it is a balance that courts works on with prosecutions in terms of the time to trial, cooperation with the court, of course, and how these things are managed. But compared to many other jurisdictions, Saskatchewan does not have the backlog of matters in provincial court that others are experiencing. And that has come about through a variety of different approaches. I think you are aware that not all circuit courts have been open to the public. During that time, the matters have been held in the permanent court locations. We've used a lot of our video that we're very proud of. We can also talk about that expansion project. But we've done a lot of things by telephone as well. And that's also with the collaboration of the Crown, and also the participation of legal aid, our colleagues who are here today, in terms of being able to try to expedite matters through the court as much as possible.
So when you talk about, increased cases, especially through the pandemic, are we talking about all types of cases in that case? Because I think there can be civil proceedings and so forth.
So the majority of these are going to be cases under the criminal code. The provincial court, of course, is the first court of record in the province, but most civil matters, civil family matters, would be held in the Court of Queen's Bench. So you can take the assumption that these are mostly criminal matters. There'll be some traffic matters in there as well, but for the most part, we're dealing with criminal matters.
Okay, thank you. I appreciate that that distinction as a bit of a novice here. And also, have the courts seen any disruptions due to staff absenteeism?
So maybe I'll talk about how things have been managed in the last couple of years, if that's helpful. After the initial decisions taken in the spring of 2020 of how we were going to manage this, we were fortunate enough to have a number of term positions assigned to the court, both for the court staff themselves and for court security, that allowed us to be able to keep managing things. We needed more people to take on some of the regular jobs because they were more time consuming. One would think that perhaps doing things by telephone, you would use less people, but that's not the case. You have to still prepare the files and be ready, and often the use of technology, you're involving actually more people to manage things in that way. I think collectively for the court, for court services, for the Crown, for legal aid, and our partners in corrections, I think we managed things quite well, but it was helpful to have these additional people to be available for that. We were able to actually reduce the amount of overtime that we have been showing over the last few years because of this other deployment. We didn't have a larger number of people on sick leave or any of that during that time. In fact, if anything, we had to really work hard at our vacation liabilities. People are very dedicated that work in courts. There is a number of them who have been there for many, many years. And I hope I'm not on a tangent, but just as an example, we recognize in our ministry now those that have more than 40 years in one area. And last year we presented a token of appreciation to 24 employees in courts that had been there for more than 40 years. So I think it gives you that indication of how dedicated our people are. However, it means they have a lot of vacation leave owing them. And so we're always balancing that. Some of our additional resources helped with that. But in terms of the overall, like, sick leave and all of that, we didn't have any greater number. In fact, I think we had less. And I think that speaks to the character of the people who actually work in that system.
Well, that's good to hear. When you talk about term appointments, I'm curious to know what are we talking for? What are those what are the roles that you're using term appointments for, and how you're recruiting and the qualifications, just, you know, the system around that process?
So I would say that there's probably 4 categories of term employees that we look to initially in court services. We have our court administrative staff who work in the office. They work on the front line counters that you see when you come into court offices. They process a lot of the payments. We also, of course, have the fine revenue branch that collects all of the fine revenue for the province. So we have a number of little categorized as court admin positions. We have our judicial officers who work directly in the court. They are the clerks in the court with the judges. We have our technical group. We have a court technology unit that is dedicated to the court, and in part they're there because of the separation with the judicial branch and the need to have their own system in place. And we also then have deputy sheriffs who are remaining in court services for another 28 days, and then they will join the new Provincial Protective Services branch. So within each of these areas, we needed to augment staff. We needed to do more security in some of the locations that we were moving into. We had moved trials off-site because we didn't have the capacity, the space in the courthouses to hold these. So we started having trials at the Centre of the Arts and at Evers Place and a couple of other places in Saskatoon, etc. It takes more people when you're in that. We needed the distancing to be involved. We needed more technology. I think I'm very proud of the amount of video conferencing that the province had prior to the pandemic. We had close to 200 video endpoints in the province, and again, we received the nod to expand that in the summer of 2020. We're still working on that project. There's a lot more we can do. So we needed more technologists in that regard, so we went looking for them. So with each of these group, you've asked about their qualifications. Each of them have very specific jobs that are well documented. We are, always in the business of staffing in those type of categories, so we know who can perform those jobs. And we just doubled down, if you will, to attract people to come in to assist in the various areas that we needed them. We could certainly provide position descriptions of qualifications, that type of thing, if that was helpful.
Thank you. That would be appreciated. Now, I understand that you're just in the point of, pardon me, just in the process of implementing your forecasting system, and these obviously, if you're using term appointments, you're anticipating this being sort of a temporary need. So I'd just like to understand both what you're seeing so far in terms of caseloads, or not caseloads, I guess, in sort of incoming and like, what's the projection right now in terms of, are you anticipating that there's going to be some sort of a leveling off or a decrease, and if so, why? And if not, then, I mean, how are you going to be preparing for that?
So on the question of being able to predict the demand for services in court, we certainly always look at the trend line. We look at where offenses are occurring, what kind of offenses are occurring, what the crime rates look like, all of those factors. But of course, courts doesn't originate any of that work. It is work that comes to the door. That's why we look historically a lot, and we look at it in different areas of the province to be able to understand if there's escalation in the number of matters that are reported to the police, of those incidents, how many of them go to charge, how many can be dealt with before a court process, how many of them can be dealt with when they first come to the court or stay in the court. So it's very hard to predict, for me to sit here with all honesty and say, well, no, I can guarantee that the numbers will be different next year. All we can do is look at the history of the numbers, which I indicated are rising, and we need to be able to operate at the level of the current volumes that we have. And as I mentioned, for provincial court in appearances, that's 1.2 million. One of the things that we're doing in terms of the data analysis, and we're very excited about this, and I feel like we're just really on the doorstep. Had we been here in June, we would have had something different to show you in terms of the work that we're doing as part of the collaboration with our colleagues in both ministries. We're trying to look at some of the other variables. Appearances is one measure, and as you can appreciate, that's the number of times a person would be in court. But what we haven't had very good data on is the individual themselves. We know how many people are in the court, but we're trying to do more analysis about how that person moves through the court system and be able to calibrate some of our measures against the number of people that are in the court, not just the number of appearances that are in the court. And that's one of the goals and one of the things we're looking at in the dashboard. So we're very excited about that because it will give us, I think, better information about what we can do in that regard. A lot of that's paired with how people are appearing in court. And if I go back to talk about video appearances, we have close to between 25-30% of people appear via video for all of those matters. So that's quite a lot. But if we look at those that are there for a first appearance, so that's their very first time in court, we're at about the 50% mark of people appearing by video. Many of them would be in custody, of course, and the court has a preference often for seeing people in their first appearance by video. It saves people being transported because that first appearance is often the time when the next steps get decided. It's not uncommon, and you will see this in the paper if you read about cases for a person at first appearance to say, well, I need legal counsel. So nothing substantive happens with respect to the charge or the way forward. It's a very valid request, and if there are ways that we can expedite those types of requests through video, then that's exactly what we want to do. I'm sorry, I don't think I've answered your full question there.
Well, I guess it was kind of twofold because on the one hand, of course, I appreciate you don't really control sort of what shows up at the door, but you do have to plan and prepare for it. And I guess it was just I was trying to understand a little bit better how. At one point, do you make the decision that you need to, that whether term appointments are adequate, or if you need to go to the point of, permanent positions instead and expand services? Of course, also acknowledging the fact that you're looking at all these other ways of sort of meeting the need and expediting the process. That was kind of what was behind that one question. And then the other thing and I really hope I'm not sort of straying outside sort of the scope of this audit too far, but I do have this question around, and I think you touched on it a moment ago, the number of individuals in remand and how some of these changes are addressing that issue to bring it down. Also, then, of course, looking for current numbers in terms of those rates presently.
So I'll take your first question first then. You know, how do we take the decision to move from permanent to term? We actually went down that road in 2018, and we identified the number of term employees that we'd had for some time that we really think should be permanent in our system, and we were granted making them permanent, and I think it's reflected in some of the documents that you may have. So it's a consideration that we use all of the time, and it is calibrated against the workload. There is no question about that. If we don't need a term employee, they're not there. But we tend to be able to use them all, and apart because of what I mentioned with some of our permanent staff, we always need coverage for people who are on their vacation time and in the eventuality that people might be on sick leave. In courts, like so many other things, the amount of time is one of the key factors. And if you have more people that can do the same task, it speeds things up. And speeding things up is usually a very good thing. It can get to matters more quickly and can take on additional duties. So there's never a time when we have someone showing up where there isn't a lot to do. There is always a lot to do in that regard. So we'll calibrate that. None of us know what this next year will bring. If we get to a point this year where we really don't have the need for the term employees, then those terms will end and we will carry on in that way. So that's how those calibrations are made. With respect to your second question, I don't have the numbers of remand or any of that. That would be better directed to some of my other colleagues.
Okay, thank you very much for those responses. It's been very helpful to have a better sense of those issues.
Just making sure that there's, looking to see if there's any other questions. Mr. Nerline.
Yes, thank you. Could you go back to the 1.2 million court appearances? That's a shocking number, I might say. Can you define appearance? Does that, so is that, if somebody comes in with five charges against them, is that 5 appearances in one case, or is that one appearance? And then second, can you tell us how many people that 1.2 million represents, roughly? Just ballpark.
I would rather give you the specific number. I would rather provide that number to the committee than to give you a ballpark number that might not be right. But it is the appearance is every time a person is in court on a matter. So it's a count in that particular way.
So I assume then you'd be able to say that an individual has appeared 5 times during the course of a year or something along that line, so multiple appearances.
Often multiple appearances, and if we do, it will give you a number that I will then double check and send you the correct number. But when we look at the average number of charges for someone appearing in criminal court, a rough average is about 2 to 3 charges per individual. And again, that's a rough number. We'll get you the exact number, but on average, that would be the average. And not all go forward, and that is a whole other complicated discussion that I don't think we want to get into today, and better left to my colleagues in correction, or in, sorry, crime prosecutions and legal aid to talk with you about that.
Thank you.
Thank you very much for the question and for the responses. Any further questions with respect to Chapter 33? Not seeing any at this point, I'd take a motion to conclude consideration of Chapter 33. Moved by Mr. Friesen. All agreed? That's carried. We will progress with our agenda and we'll move into the Office of the Public Guardian and Trustee of Saskatchewan. And I'll turn it over to the Office of the Provincial Auditor to focus on Chapters 9 and 30, respectively.
So Jason Bondi is going to present the two chapters in a combined presentation with regards to the Office of the Public Guardian and Trustee of Saskatchewan. There is one new recommendation for the committee's consideration within these chapters, and I do want to thank management and staff at the office for their cooperation that was extended to us during the course of our work. I'll turn it over to Jason.
Thanks, Tara. These two chapters on providing property guardianship services to adult clients at the Public Guardian and Trustee include the original performance audit with one new recommendation and the subsequent follow-up. The Office of the Public Guardian and Trustee has almost 1,200 adult clients under property guardianship who do not have the capacity to manage their own finances and property. It is important that the office has processes to ensure the financial affairs and property of vulnerable adults are appropriately managed. Property guardianship services for adult clients includes making decisions about an adult client's estate, such as financial planning and paying expenses and debts. It does not include adult client care decisions such as where to live or medical decisions, or decisions about making a last will and testament. Those are roles of executors or beneficiaries. The office is an agent of last resort in that no other suitable individual exists. Chapter 9 of our 2020 report, Volume 1, reports the results of our audit of the Office of the Public Guardian and Trustee of Saskatchewan's processes to provide property guardianship services to its adult clients. It contains one new recommendation for the committee's consideration. For the period ended July 31, 2019, the office's processes were effective to provide property guardianship services to its adult clients other than in the area reflected in our one recommendation. My presentation will focus on the one recommendation. I will also present the results from our first follow-up. On page 111, we recommend the Office of the Public Guardian and Trustee of Saskatchewan follow its established processes to keep rationale for key decisions about identification of property of adult clients receiving property guardianship services. Although the office identified, investigated, valued, and recorded client property within a reasonable time frame, it did not always document in client files rationale to support their conclusions around results of property identification searches. Keeping documentation of key decisions in client files would support the judgments made and ease transitions of clients between trust officers, for example, in the event the assigned trust officer is on leave. In Chapter 30 of our 2021 report, Volume 2, we reported that the office implemented this recommendation. By July of 2021, the office developed and implemented a new form to document rationale for key decisions about property searches for adult clients receiving property guardianship services. I'll now pause for the committee's consideration.
Thanks for the follow-up on this front, and thank you. And I'll turn it over to Ms. Head for brief comments, then we'll open it up to the committee for questions.
Thank you, Mr. Chair. So as indicated, there's only one recommendation arising out of this audit. The recommendation relates to ISC searches done by Public Guardian and Trustee to determine whether new clients own real property. In some instances, the searches may produce results for people with similar names, and further investigation is required to determine whether the client owns real property. The auditor found that 2 of the 18 files reviewed that while they did not own real property, the decision had not been documented to the file. Documenting the rationale for key decisions supports the judgments made in specific instances. Keeping documentation of key decisions in client files would ease transition of clients between trust officers in the event a trust officer was to leave the office. So in response, in December of 2019, the PGT created and implemented the use of a new form entitled ISC Search Possible Match Form, which provides for documentation to file with respect to the decision as to whether or not the client is the owner of real property where there has been a possible ISC match. As this recommendation has been implemented, that concludes my comments on this chapter, and we just welcome if there's any questions.
Thanks for the work on this front. Those comments, I'll open it up to the committee if there's any questions. Ms. Ritchie.
Thank you, Mr. Chair. I see on table, page 109, a table identifying total adult clients and total FTE trust officers for 2018 and 2019. And I'm wondering if we could have updated numbers for 2020 and 21.
So I'll introduce Carolyn Decker here, seated to my left, who is the Deputy Public Guardian and Trustee, to respond to that question.
I can provide, we can provide 2020 information to the committee. I don't have that today, but I do have our numbers as of March 31st, 2021. At that point, we had 1,263 clients under adult guardianship. We did receive additional funding in our recent budget since the audit was done, and we now have 12 full-time trust officers, and we've gone from 1 to 2 supervisors for the adults unit. Both the supervisors have a very small caseload, but the trust officers on average have 104 cases per trust officer at this point.
Okay, thank you. Appreciate that. Yeah, so you indicate an increase over previous years there, and I note between 2018 and 2019 it was 8.6% increase. I'm just wondering if you can speak to any trends or assumed reasons for an increase in case files?
We suspect it's just an increase in population within the province. Our clients range from 18 to up to 100, and they come to us with various issues, everything from developmental delays to mental health problems to acquired brain injuries to dementia. We do have a growing elderly population in the province, so we are seeing increases with respect to clients in that range. But also just as our population grows, we anticipate our client base will increase as well.
Do you monitor and analyze those trends to sort of gain insight into what's occurring?
We do try to look at what is coming from Stats Canada and whatnot with respect to what we're seeing. We also do track our client caseload on a monthly basis so that we can see where there's increases. It also assists us in assigning clients to our trust officers to try and keep their caseloads balanced and make sure that they have that they aren't too overwhelmed and can provide services to the clients.
Okay, thank you for that.
Any further questions on the new recommendation with respect to Chapter 9? Of course, we've heard the actions that have implemented this recommendation. Not seeing any. I would welcome a motion to to concur and note compliance with recommendation number 1 in Chapter 9. I see Mr. Skoropat has moved. All agreed? That's carried. And with respect to Chapter 30, there's no new recommendations there. We simply need to conclude considerations. Anyone care to move that? Mr. Nerline, is that agreed? Okay, folks, we'll turn our attention to the Office of the Residential Tenancies, and I'll flip it over to the Office of the Provincial Auditor to make their report.
So thank you, Mr. Chair. With me is Mrs. Kim Lowe, who led the work at the Office of the Residential Tenancies. There are 3 new recommendations in this chapter for the committee's consideration. I would like to thank the Director of the Office and her staff for the cooperation that was extended to us during the course of our work. I'll now turn it over to Kim.
Thanks, Chair. The Office of Residential Tenancies is responsible for adjudicating disputes between landlords and tenants. For the 9 months ending December 2020, the Office of Residential Tenancies received over 2,500 applications and held over 2,000 hearings. Typically, the majority of the applications are for urgent situations, such as those involving eviction, where tenants have not paid rent or rent is in arrears, and where rental property is not properly repaired. Having an effective adjudication process helps ensure landlords and tenants have their disputes handled fairly and impartially. It also reduces the risk that tenants remain in unsafe living conditions or landlords endure undue financial burden for long periods. Chapter 9 of our 2021 report, Volume 1, reports the results of our audit of the Office of Residential Tenancies processes to adjudicate tenancy disputes. It contains 3 new recommendations for the committee's consideration. At December 2020, the Office of Residential Tenancies had generally effective processes to provide timely adjudication of disputes of eligible landlords and tenants with improvements needed in 3 areas. I will focus my presentation on each of the 3 recommendations. On page 120, we recommend the Office of Residential Tenancies provide clear and written guidance, including examples about what constitutes a conflict of interest to hearing officers. The Office of Residential Tenancies does not give hearing officers any guidance on what constitutes a conflict of interest, even though it asks them to declare conflicts of interest when being assigned a hearing. During the audit, we saw evidence of hearing officers declaring conflicts of interest prior to a hearing. We did not identify any cases of conflicts of interest. Not having written guidance on what constitutes a conflict of interest increases the risk of hearing officers not declaring conflicts of interest or not taking a consistent approach to identifying and declaring conflicts. This in turn could impact the risk of bias, either real or perceived, in decisions issued. On our second recommendation is on page 126. We recommend the Office of Residential Tenancies document reasons for significant delays in issuing hearing decisions. The Office of Residential Tenancies does not always document reasons as to why it issues some decisions significantly later than expected. Our data analysis of the 2,488 decisions issued in 2020 calendar year found the Office of Residential Tenancies most often issues decisions promptly. Only 17%, or 430 decisions, were issued later than its target of 2 days. We found hearing officers did not always provide the Office of Residential Tenancies with reasons for not submitting a written decision within the target time. For each of the 9 decisions we tested that were submitted to the Office of Residential Tenancies 20 days later than its 1-day target, the hearing officers did not give the office reasons for the delay. Significant delays in issuing decisions increases the potential of tenant and landlord's dissatisfaction with the adjudication process and having disputes remain unresolved for long periods of time. It also increases the risk that decisions may no longer be relevant once issued. Having tenants and landlords wait for a decision can potentially cause undue hardship for extensive periods of time. Our third recommendation is also on page 126. We recommend the Office of Residential Tenancies always follow up promptly with hearing officers when hearing decisions are not submitted when expected. The office does not always make sure hearing officers issue written decisions within a reasonable time. We found the office did not always ask within a reasonable time whether within reasonable time hearing officers to submit late decisions and explain why they needed additional time. For 4 decisions we tested that were submitted more than 20 days later than its 1-day target, the Office of Residential Tenancies took between 43 and 77 days after the hearing date to follow up with the hearing officers. Not following up with the hearing officers that have not submitted decisions increases the risk of significant delays in issuing decisions, that is greater than 20 days. Similar to recommendation 2, significant delays in issuing decisions may lead to tenant and landlord dissatisfaction with the adjudication process and leaving disputes unresolved for long periods of time. It also increases the risk that decisions may no longer be relevant once issued. And that concludes my presentation.
Thank you very much for the presentation and the focus of this work, and thank you as well to the office for their response and their actions on this front. I'd welcome Ms. Head to bring brief remarks, and then we'll open it up for questions.
Thank you, Mr. Chair. So I would just like to note, I've been joined at the table here by Anne Marie Cotter, who is the Director of the Office of Residential Tenancies, who has been working away very diligently to implement these recommendations, and we appreciate the auditor coming in and bringing these matters to our attention. So regarding recommendation number 1, the ministry considers this matter implemented. The hearing officer onboarding manual was updated in January 2022 to include a link to the Law Society of Saskatchewan's definition and examples of conflict of interest. These were also communicated immediately to hearing officers at the annual meeting in April of 2021. The manual also clarifies when a hearing officer should be notifying the ORT of any perceived or actual conflict of interest. Regarding the second and third recommendations, the Office of Residential Tenancies is now following up with hearing officers twice per week to provide a rationale for outstanding decisions. The ORT is also now documenting the outcome of that decision. So we welcome any questions from the committee.
Thank you very much, and I'll open it up to committee members for questions. Ms. Ritchie.
Yeah, thank you. Thank you for that progress report, and happy to see that all have been implemented. And I just wanted to ask, it's probably in the binder, but maybe you could just highlight for me anyways, the nature of the conflicts that you were mentioning, and happy to hear that those have been presented to officers. There's a full understanding. It sounds like, I don't have any concerns with the report you just gave, but just for my own personal benefit, if you wouldn't mind just kind of explaining to me what those conflicts, the general nature of them.
Thank you very much. I'd like to say thank you for the committee members today for allowing me to speak, and I wanted to extend my thank you as well to the auditor team. It was a pleasure to have them at the office. So all of our hearing officers are lawyers, and our hearings are held and heard by hearing officers and deputy directors. The typical conflict of interest that we've seen, it would be former clients of a hearing officer that might have been in previous practice or is in current practice. So as soon as they see the name, they'll flag it for us, and they'll say that they cannot hear that case. So that would be the typical. And as the auditor pointed out, there have been no cases identified with a conflict of interest in our office, but we do welcome the recommendations that we put into place immediately.
Great. Thank you very much for that.
That's it. All right. Well, thank you. Thanks for all the work on this front and the report of the actions that have been taken and the service that the office fulfills to Saskatchewan people. Looking to committee members, I don't see any other questions on this report. This chapter, I would welcome a motion to conclude considerations. Oh, sorry, these are brand new recommendations. We haven't considered them before. So I'd welcome a motion to concur and note compliance with recommendations 1, 2, and 3, moved by Deputy Chair Young. All agreed? That is carried. All right, we're going to change. You bet. We're going to change gears here. I just want to thank everyone that's come in this morning through the Ministry of Justice, Assistant Deputy Attorney General Head. Thank you for your leadership here today. All officials that have been present, and importantly, all those folks that are involved in this work across Saskatchewan and carrying out the duties and service to the people of Saskatchewan day after day. So thank you for your time. We will take about a 5-minute recess here, and then we will reconvene with the Ministry of Justice and Attorney General with a focus on the Ministry of Corrections and Public Safety. Okay, we'll reconvene the Standing Committee on Public Accounts, and we'll move ahead with our next set of considerations on the agenda. I'd like to welcome the officials that have joined us here today. Ms. Alexander, I would ask you to briefly introduce yourself and your title and the officials that have joined you here today. We will then turn it over to the provincial auditor to introduce her chapter, and we'll take it back to you for remarks subsequent to that.
Good morning, everyone. Nice to be here. Thank you to the committee for having us here today and to discuss Integrated Justice Services progress on the provincial auditor's recommendations. Thank you to the provincial auditor and her team for the work that they do. My name is Gina Alexander. I'm the Executive Director of Community Safety and Wellbeing, part of Community Engagement branch, which is part of Integrated Justice Services. And my colleague to my right is Scott Heron. He's Executive Director of the Research Implementation branch, also of Integrated Justice Services.
Well, thank you so very much for being here today and for your work. I'll table at this point PAC 5029, Ministry of Integrated Justice Services status update dated March 2nd, 2022. I want to thank the folks that have put together the actions and detail in that status update, and of course those that have been involved in that work. At this point in time, I will turn it over to the Office of the Provincial Auditor, and I believe their focus will be on Chapter 8 of the 2021 Report, Volume 1.
So thank you, Mr. Chair, Deputy Chair, committee members, and officials here today. Mr. Jason Wandy, Deputy Provincial Auditor, will present the chapters related to both ministries in the order that they do appear on the agenda. He plans to present the second and third and the fourth and fifth chapters together. He will pause for the committee's discussion and deliberation after each presentation, and there are 7 new recommendations for the committee's consideration. I do want to thank the ministry officials for the cooperation that was extended to us during the course of our audit work. And I'll turn it over to Jason.
Thanks, Sarah.
This chapter is a joint chapter. This chapter is a joint chapter of the Ministry of Justice and Attorney General and the Ministry of Corrections, Policing and Public Safety. I will refer to these as the ministries throughout the remainder of this presentation. Chapter 8 of our 2021 report, Volume 1, reports the results of our audit of these ministries' process to implement strategies to reduce short-term remand in Saskatoon and the surrounding area. It contains 6 new recommendations for the committee's consideration. Between 1998 and 2018, the average annual count of adults in custody in Saskatchewan increased by 48%, with the primary reason for this increase being adults on remand. At the time of our audit, individuals held on remand represented almost 2/3 of individuals admitted into custody and over 40% of individuals in custody on a daily basis. This increase puts pressures on the provincial correctional system. Decreasing remand populations is complex and requires long-term commitment, ongoing coordination, and balancing of two competing principles, respecting liberty rights of the accused and ensuring public safety. The ministries initially applied their strategies for reducing short-term remand in Saskatoon and the surrounding area, in the hopes it would serve as a model for other regions. The strategies in use at the time of our audit are outlined on page 95 and include early case resolution, rapid remand response, and community alternatives to remand. For the period ended September 30th, 2020, the ministry's processes were effective to implement their strategies for reducing short-term remand in Saskatoon and the surrounding area, other than the 4 areas addressed in our 6 recommendations. My presentation will focus on the 6 new recommendations. In our first recommendation on page 100, we recommend the ministries focus on collecting data for key measures and establishing associated data definitions for evaluating the strategies to reduce short-term remand. The ministry had a draft evaluation plan that identified 48 measures across several categories. We found the evaluation plan remained in draft and was not approved, that it was broad in scope and had a large number of measures that may reduce the ministry's ability to appropriately evaluate strategies timely. In addition, it didn't establish data definitions or set out timing for periodic evaluations. Data collection takes time and effort. Therefore, not focusing on data collection for key measures increases the risk of inefficiencies and lack of buy-in for partners who provide data. In addition, measures about the operation of remand strategies would increase the ministry's understanding of whether it is the remand strategies or some other factors impacting the achievement of targets. As well, establishing data definitions can reduce the risk of users not understanding, using, and interpreting the data correctly. Recommendation 2 is on page 101. We recommend the ministries establish targets conducive to measuring whether they are reducing short-term remand. The ministries established a target to maintain 0 growth of overall remand. However, we found this target does not measure key outcomes of the initiative, such as whether the remand initiative helps reduce unnecessary time involving police detention and court processes, and reduce unnecessary time involving remand. Targets set out how quickly and to what extent an organization expects to make progress. Not having targets that provide insight into measuring outcomes makes it difficult for the ministries to know whether the remand initiative is making sufficient progress. Our third recommendation is on page 102. We recommend the ministries collect and analyze key information from external partners when evaluating strategies to reduce short-term remand. We found the ministries collected and validated some data related to their draft evaluation plan, but did not collect key data from 2 of their external partners as planned. Collecting key data from external partners would give the ministries information about the partners' operations, allowing for assessment of possible external impacts on the remand strategies. In addition, this would enable the ministries to appropriately analyze the progress on remand initiative outcomes, such as reducing unnecessary time involving police detention and court processes. Lack of key data could also impact the ministry's ability to determine whether the key external partners are committed and sufficiently engaged in reducing short-term remand. Recommendation 4 is on page 105. We recommend the ministries include context, data limitations, and key assumptions relevant to making informed decisions within evaluations of the strategies to reduce short-term remand. The ministry's key method of evaluating remand strategies is through periodic program evaluations. During our audit, the ministries completed a program evaluation for one of their strategies, the Community Alternatives to Remand program. We found this evaluation did not clearly set out the context of the evaluation. For example, time constraints, extent of the analysis, or acknowledge data limitations, such as the lack of a control group in the analysis. The evaluation also did not clearly set out key assumptions made in the economic analysis. Without robust and clear documentation of data limitations and analysis to support the ministry's program evaluations, key decision makers may not have sufficient information to make informed decisions. Our 5th recommendation is also on page 105. We recommend the ministries routinely analyze data for key measures associated with the strategies to reduce short-term remand. We found the ministries regularly collected information from community-based organizations about one of its strategies, the Community Alternatives to Remand program. However, the ministries did not take a proactive approach to evaluate this information on a routine basis. The ministries did not formally evaluate the information and consider possible root causes for low program utilization until its 2020 evaluation of the program. This program was discontinued effective March 31st of 2021. Routine analysis may have enabled the ministries to identify necessary program adjustments that could have contributed to the success of the program. Routine analysis of whether remand strategies operate as intended can assist the ministries in being more proactive in their response to making informed decisions about necessary changes to the strategies. Our last recommendation is on page 108. We recommend the ministries determine the information needs of the remand committees used to support the remand initiative. We found the ministries communicated with senior management and the provincial steering committee about the evaluation of remand strategies completed to date, but they need to determine the information needs of the remand committees. For example, the ministries did not formally report to the steering committee on its only remand target to maintain a zero growth rate in remand. Not regularly providing committee participants with key information about how well the remand strategies are progressing increases the risk of not engaging committee participants and not keeping them sufficiently informed. Not setting out expectations for information sharing, including frequency, increases the risk that this will not occur. I will now pause for the committee's consideration.
Thanks so much for the focus of the audit, for the presentation here today, and thanks as well to the folks at Justice and the Integrated Justice Services for the real detailed template that they've filled out here and all the actions that have been taken towards implementation. I'd introduce or welcome Ms. Alexander to present remarks, and then we'll open it up for questions.
Thank you. I will turn this over to Scott Herron.
Thank you, Mr. Chair. Based on the recommendations, standard operating procedures have been developed for program design and monitoring, including the development of key metrics. Standard operating procedures have also been developed for data collection and reporting. These procedures were finalized in February. These actions address the recommendations made and will benefit future actions, and new programs and research being designed are already using these standard operating procedures and have been for some months. Beyond these procedures and beyond the recommendations of the auditor, the ministries are developing a dashboard that will provide weekly monitoring on short-term remand among a host of other measures. This dashboard will be deployed in 2022. Further, the ministry has adjusted our focus from short-term remand to reducing the likelihood of that an individual returns to custody, a longer-term goal. This focus will include short-term remand as a measure of success rather than as the ultimate goal. Regarding recommendations 1, 2, 3, and 5, new programs that will be designed will include performance measurement framework and data definitions that will be co-designed with delivery agencies. Third-party contractors are also being used to help establish these performance metrics and appropriate targets during program design. By applying standards formalized from the recommendation of this audit, we will be ensuring that we're collecting useful data from the right parties and regularly monitoring progress rather than waiting for a final evaluation at the end of the pilot. Regarding recommendation 4, these standard operating procedures include guidelines for program design and monitoring, as well as data reporting. We have incorporated the recommendations and procedures into other branch initiatives, including specifying limitations and key assumptions. Regarding recommendation number 6, following project management government practices, the ministry has streamlined governance and now has one internal committee that oversees actions to focus on reducing returns to custody. Additionally, the dashboard will provide weekly monitoring and information to the committee, as well as ministry leadership right across the ministry on short-term remand as well as other measures. This concludes my remark. Happy to take any questions.
Thank you so much for that presentation and for all the work on this front. I'll open it up to committee members for questions at this time. Ms. Ritchie.
Thank you, Mr. Chair. My first question is for the provincial auditor, and maybe it's more sort of a procedural. I note that there are a number of status items here, or recommendations here that have a status of implemented, but then they indicate that there's some additional follow-up work through contracting third-party providers. And would it be typical to conclude implemented if things are not fully implemented?
So in terms of our follow-up process, this is a fairly current audit, so we will undertake a follow-up audit probably in another year or two. So we usually determine that the agencies will take, at least 2 to 2.5 years to implement some recommendations, some longer term than that, some we believe 5. So I can't confirm that they are implemented at this point. We will come back, do that audit as such, and then provide assurance at that time. In terms of do we give a pass or say something's implemented, though, if it is in progress? We do sometimes. So if we can see that, the ministry has contracts in place, there is that data analysis taking place as such, reports are going forward, committees are in place, we feel like the process will be sustained in the longer term, we do then sometimes say that we do to consider that process to be implemented, and we do envision that it'll be utilized over the longer term.
Thank you for that response. And just a second question I had for you. And it's not really so much specific to this particular audit, but there seems to be a bit of a I'm identifying a little bit of a pattern or a trend here, in terms of the kinds of findings, whether it's collecting and analyzing data and having, the right criteria in place, a lot of this forward upfront work one does to ensure program efficiency and effectiveness. And so I'm just wondering at what point you sort of go beyond sort of saying, okay, well, you're missing these elements of your management and governance system, to delving into why has that occurred in the first place? Do you as a root cause, perhaps?
Yeah, and I would say when we are formulating a number of our recommendations, you're right, we're always trying to step back and think what is contributing to the issue but that has been identified. That said, we rarely make recommendations with regards to it's about the need for additional capacity. We always believe what it is that the government agencies need to, like you said, determine what are you trying to succeed, what are we trying to achieve here, do I have the data, am I analyzing, do we feel like we're on the path to meet those targets and measures that we've established, and then as such, they need to do their own determination as to what those factors would be that they may need to put in place to implement and get those actions moving farther than they are at this point. So that said, we are doing a better job when we do our audit work to sort of say, we know this is an issue, now why is this occurring? Is it because of staff training? Is it because of lack of policies? Is it just a lack of data is there, but it's not being utilized? And can we take that data, analyze it, and give you context as to what you would see and the agencies might see if they did so do that analysis.
Appreciate that explanation. Thank you so much. Okay. So with that, Mr. Chair, I do have some questions now for the ministry. And maybe just to start by thanking you both for your presentations and the information that you've provided. I do have a number of questions here, and I'm not sure I'll get to all of them, but I'll maybe start with, you made mention in your report of shifting your focus from short-term remand to what sounded to me like recidivism, but you didn't use that word, and a little more of elaboration on how you're shifting your goals and targets.
Perfect. Absolutely. So the difficulty with short-term remand, it is a piece, an important piece, but still just a piece of a very complex system. And at the end of the day, what the system is all about is really trying to get people out of that cycle of reoffending, getting them reintegrated into communities in a safe manner. And by focusing primarily on short-term remand, it didn't really give us the focus that we need to manage to look at that bigger picture. So, post-audit, we did a lot of analysis during COVID as to what was happening with the custody population during COVID, and came up with a bit of a different approach to try to get people to break the cycle of reoffending. And that's to take a kind of an elevated approach, a more partnerships approach, a more nuanced approach. So what we're trying to do is, instead of looking at the custody population as a big monolithic whole, separating it into individual groups, using data analytics and saying, okay, we've got a group of 300 people here. What can we design that's specific for them in terms of the audit? What specific targets are needed for them? What specific measures, what limitations does that specific group have? And by doing that, we're hoping it's going to be a whole heck of a lot more successful.
Thank you for that. Also, I do note that I think in a few different instances here, you indicate that you'll be bringing in third-party contractors to assist you with your implementation, and want to understand, is this like a one full service provider assisting you with all of these measures, how they're being selected, what qualifications that they bring in doing this work? Just anything more you can tell us about that.
It will depend on the program, but the main one we're using is our university partners, the University of Regina and the University of Saskatchewan. The ministry has a collaborative research agreement with both organizations that we recently redid to provide a lot more flexibility. So we go to our university partners, either one, we say, hey, we've got this new program we're being developed, or we've got this new evaluation we want done. Do you have somebody that wants to partner with us on that? And they have some fantastic experts, some leading people in the country there who partner up with us. Dr. Lisa Jewell is at the University of Saskatchewan. She tends to be our main one, and she's absolutely fantastic, does fantastic evaluations. We've got an agreement with Dr. Stuart Wilson, who I think is the head of the economics department now, who works with us on the economic portion of it, as well as Dr. Hamilton with the computer science division, who's helping us with that dashboard. And phase 2 of that dashboard, and Ms. Turner talked about that dashboard as well, it's really to bring measures from right across the system, everywhere from courts to community corrections, into one spot. And Dr. Hamilton is helping us take that into a forecasting into the future as one of the future areas. So they're the ones we primarily use, and there's tons of expertise there.
I note that in the auditor's report, there's a fair amount of discussion around the Community Alternatives Program, which, in listening to that presentation, it seemed to suggest that had there been sort of analysis upfront, data analytics, some other evaluation, perhaps that program may not have met its demise, I suppose. So it's kind of a twofold question here, both in terms of, explaining, in the first instance, the reasons for why the program was canceled, but then, sort of further to that, also, what might have prevented that from happening in the first place?
So following the auditor's recommendations, certainly we should have been doing more frequent program evaluation on that. Now, there were committees that were in place. I think Regina's Adwan PA was meeting that were dealing with the kind of on-the-ground things, but we should have been able to do that. The pandemic got in the way to some extent, and we didn't have the plan at the front end that we should have. Now, the program at the end of the day was not renewed. It was a pilot, so it was a decision of whether to continue the pilot or whether to direct the funds somewhere else. We didn't see the level of success we wanted to see out of that pilot. The success rate was essentially it was about 15% or less. 40% of the people who were involved in that program actually resolved their matters within a day or two, so they never actually had the opportunity to connect with any of the resources. That's actually a good news story to some extent. Saskatchewan has the highest 7-day resolution rate of criminal cases in Canada. We resolve 26%. The average for across the country is 11%. So we're more than double the national average, and that's compared to 8% in Ontario, so it's not necessarily a bad thing. 30% of the people who were referred to this program ended up being released from custody and then never went and actually attached to those resources. And these are individuals who otherwise would not have been released. And half of the people who did get released and connected to the resource still reoffended. And half of those were reoffending on administration of justice charges. So the success rate was quite low. In regards to the comment about whether frequent evaluation would have been able to save this program, as it were, I don't think so. There were some fundamental challenges with how we designed the program. The biggest one being that the remand system is extremely unpredictable. You have no idea going in whether somebody's going to be there for 1 day or 1 year. It really depends on the individual and what their personality is and what the charges are and who their lawyer is and all kinds of different types of things. The second part of that was that a lot of these people are dealing with very substantive, lifelong challenges, and you can't do much in, say, even 4 weeks, which is what the program was planned for. So it was the right idea in the wrong place. And when we went to all of our community partners, that was the message we got from them, was right idea, wrong place. So we decided, okay, let's not continue with this, but let's take that money, let's dedicate it to a new program that takes more of that nuanced, longer-term approach. And that's what we've done. Right now we have something called the Back to Basics program, which is out for RFP, which is specifically focused on female offenders who are cycling in and out of custody on relatively low-level things, and saying, let's design a program specific for them. Let's give them supports for up to 18 months, and let's get them out of the system permanently rather than worrying about if they're in custody for 1 or 2 days.
What was the, when the program was first introduced, presumably there was some sort, there would have been a basis for proposing the pilot in the first instance. Was that based on other jurisdictions, or can you explain to me how it originated?
I can give a general overview. I was not in this role at the time it was implemented. You work, when you come up with a program, you work with what the information you have is at the time. And back in 2015, kind of when the remand initiative started, we saw very steep increases in the remand population, and we wanted to say, okay, what can we do about that? The general assumption or the general narrative that was with a number of partners was, well, if we had a place for these people to go, if we had a place for or if we had some wraparound supports, we wouldn't have to keep them in custody. We could have them safely in the community. And that's kind of the basis for which the Community Alternative to Remand pilot was initiated, to say, okay, that's the narrative. Let's give this a try. Let's see what actually happens. And then we saw the results by the end of it. There's 88% of the people on remand currently are there with violent offenses. The more we dig into this, the more that we come up with statistics like that say that maybe that's not the primary problem. We're not saying that that's not a problem at all, but it may not be the silver bullet that we're thinking it is, and that we do need to take a much more nuanced approach based on those individual bite-sized chunks of the custody population.
Right. So with the Back to Basics program, is it that you are identifying a segment of that population that you think is there's a greater likelihood of success?
We did analysis during COVID. We found that the female offenders decreased more than the male offenders, which indicated to us that they're more responsive to change. We also found that the lower level offenses like low-level theft, property breaches of court orders also decreased much faster than, say, violence, which barely changed at all during the pandemic. So we said, okay, based on this, what if we designed a program for this individual? We actually designed a tool we're calling the Sandbox, which lets us isolate these individuals from a data perspective. Found out that on average, this group was 400 or 500 people within the province over the course of a year. They were cycling back into the system 400 or 500 entering custody, not people, some of those are repeats. They're entering custody about every 6 months, which means they're not in custody long enough to really provide adequate supports for, and they're not in community long enough to really give adequate supports for. So we said, let's take something that we think we're going to be able to affect that has a higher likelihood of change and try to give them the more comprehensive, longer-term connected supports that they need to succeed. And we'll see if that's a success. It's also a pilot.
Right. So what is the current status then of the Back to Basics program? Has it been initiated? If so, when will the pilot conclude? What resources are there to undertake the pilot?
It is currently out for an RFP. One of the lessons we learned from the CAR program was not to have government design every aspect of this. We put it to our community organizations to design it, gave them the freedom in order to do so. Our message to them essentially is you work with them on a day-to-day basis. You've got existing strengths, existing resources, existing partnerships. Lean on those and put forward your best foot, and then we'll do a transparent process to select which one it is. The program is $1.2 million, so it's actually about $300,000 more than the CAR program, in addition to the resources we're going to have to allocate internally. That's $1 million from the Ministry of Corrections and Policing and Justice, and $200,000 from the Ministry of Health for dedicated mental health and addiction supports. We'll be dedicating 2 positions internally to this, one that'll be based in Pine Grove to provide a direct connection to potential participants, and somebody down in Ms. Alexander's shop to do a program management perspective in terms of the contract and helping to work out anything like that. My team in the research and implementation branch will be responsible for constant evaluation, including likely monthly reports back to the service provider to say how this program is going and what may need to change. We took the audit recommendations extremely seriously. We also went out to all of our CBO partners and had a 3-hour evaluation discussion on the CAR program and lessons learned from us and from them, incorporated all those lessons into this new approach.
Well, that sounds like exciting work, and we look forward to hearing about the outcome of the pilot. Switching gears a little bit here, on page 97, it indicates that the Provincial Steering Committee was replaced with 2 new committees in 2020, the Custody Population Consultation Committee and the Remand Initiative Committee. Can you speak to the workings of these new committees, please?
We've actually switched gears again since the audit. We now have 1 internal committee that's made up of every ADM who has responsibility for some part of remand or some part of reducing returns to custody. And they're armed with a dedicated project manager based in best practices project management principles so that we have appropriate charters in terms of references and meetings and the whole 9 yards. They'll also have access to that dashboard that I was talking about, which means that we're going to have automated measurements weekly rather than having to do this on a yearly basis and taking up a lot of effort. The Custody Population Consultation Committee, which is the external committee, what we found and what we kind of heard from people was that it was a duplicate of what we already had in place. We already meet with our policing partners through the Saskatchewan Associations of Chiefs of Police. Prosecutions and legal aid already have lots of standing meetings, so they were finding that it was just a duplication of what we had. So we said, okay, we don't need to put more meetings on people's plates. Let's close that one down, and we'll dedicate ourselves to make sure that we're talking to our partners, both in terms of individual programs that were created and through those forums.
So as regards the internal ADM committee that you mentioned, is it possible to request a copy of the project charter, just so we can sort of see what the mandate and details are?
I can likely get you a copy of the terms of reference. The project charter, in terms of what exactly we're going to be accomplished, is still in development.
Okay, yeah, terms of reference would be great. Thank you so much. I have no further questions.
Thank you. Thank you for the questions. Thanks so much for all the work and the responses. And thank you for the focus of the audit. You know, it's substantive. It's we have 6 new recommendations before us here. Just checking to see if we have any other questions from folks. Deputy Chair Young.
Yeah, reading through some of this, and you just discussed quite a bit about the steering committee that you have and the collection of the data, but it appears that there wasn't a lot of consultation back and forth between the CBOs on the community alternative programs, because it showed, I see in here, that in Saskatoon particularly, there was an underutilization of beds, up to 58%. That's significant. It showed in here. So I just, you know, if I'm reading it right, so what communication happens with them on a regular basis to try to connect those people coming out of those short-term remands with those community alternative programs in order to utilize those beds, as well as the services that they offer to keep people from coming back?
There wasn't as much communication between, say, my team and the CBOs as I would have liked, and that's one of the things we're going to change in the future. There were ongoing discussions at the front line between prosecutors, between legal aid, between CBOs, kind of on a daily basis and a person-by-person basis around that. A lot of what we chalked the limited use of the bed space was 2 things: an overestimation of the number of people that would qualify for this program. So it wasn't necessarily that they weren't getting referred; it was that the people were not there. So we dedicated too much bed space. That was actually a bit of a challenge from our CBO partners, who had to keep the beds open when they otherwise could fill them with other people.
So they don't necessarily have dedicated beds for people coming out of remand, is what you're saying?
They did for this program, yes.
They did just for this program,
yeah,
but on an ongoing basis?
Yes. They don't outside of this program, no.
Okay.
Any further questions? Not seeing any. Thanks for the report and the work, and good question as well by the member about when the ministry has, you know, cited that they've implemented something, that there's, you know, not that we don't trust the ministry, we really do, but there's a real thorough follow-up then back with the provincial auditor and a public report that comes back out to us. I think if we look at the bulk of these 6 recommendations, the actions have been detailed, substantive, and largely concluded February 2022, which is wild that we're past that already when I think about how fast time is moving, but that's when most of these were deemed to be implemented. So I'd be comfortable to welcome a motion for recommendations 1 through 6 that we concur and note compliance. Moved by Deputy Chair Young. All agreed? Agreed. That's carried. We'll move along now, and we'll turn our attention to chapters 16 and 20, which I believe will be presented on together, and I'll turn it over to the Provincial Auditor's Office.
Thank you, Mr. Chair. Chapter 16 of our 2019 report, Volume 1, and Chapter 20 of our 2021 report, Volume 1, report the results of our first and second follow-up audits at the Ministry of Justice and Attorney General and Ministry of Corrections, Policing and Public Safety related to processes for leading the Community Safety and Wellbeing Initiative. We made 4 recommendations in our 2016 audit. The Community Safety and Wellbeing Initiative aims to reduce crime by having agencies voluntarily work together to respond to at-risk, marginalized, and vulnerable individuals and families by addressing the root causes of crime. We found that by January 2019, the ministry had implemented 2 recommendations and partially implemented a third. And by January 2021, our second follow-up, the ministry continued to work on the 2 remaining recommendations. By January 2019, the ministry worked with participating agencies to understand and accept their roles within the initiative, and clarified and provided additional direction and support to the participating agencies. In the 2021 report for the 2 remaining recommendations, we noted that the ministry had taken steps by engaging an external consultant to evaluate the initiative. The ministry plans to use this evaluation to identify success measures of the initiative. Once these measures are identified, it can analyze and report on the success. Without effective processes to measure the success of the initiative, the ministries do not know if the initiative is providing timely and valuable coordinated services, and if participation in the initiative leads to better outcomes for the individuals involved. The ministry is also unable to make appropriate adjustments to ensure the initiative addresses root causes of crime. I will now pause for the committee's consideration.
Thank you for the focus of your work, the follow-up, and the presentation here today. And these recommendations have all been considered at this table and supported at this table. I'll flip it over to Ms. Alexander for brief remarks, and then we'll open it up for questions.
Thank you. So we concur with the auditors that the first 2 recommendations are now implemented. With regard to the last 2 recommendations, the ministry implemented the use of a national risk tracking database to capture and easily report on hub table outputs, including tracking number of discussions, number of repeat referrals, and clients connected to services. In addition to this, the ministry procured the services of a neutral third party to design and deliver an outcomes-based evaluation on the Saskatchewan hub model. The evaluation commenced on November 2020, and a final report is expected in July 2022 with full implementation by fall of 2022. That concludes my remarks for now.
Thanks for all the work on this front. Thanks for the report and the presentation. I'll open it up to committee members for questions. Ms. Ritchie.
Thank you, Mr. Chair. I just have one question regarding the hub model. Can you explain to us how success is being measured for that model?
Up until now, success has been measured on clients being connected to services. The hub model is designed to identify and address those individuals or families and communities that are experiencing acute and elevated risks of harm. And so when a group of individuals in a community, human services individuals in communities, including representatives from social services, representatives from education, municipal and RCMP, probations, and mental health, when they convene to understand and see that someone might be at elevated risk, they intervene in a way that connects, asks those individuals if they would like to get connected to services. So to date, our success measurements have been on the hub's ability to connect people and individuals, families to services.
Okay, thank you very much for that answer.
Thank you for those responses. Looking to committee members to see if there's any other questions on this follow-up chapter. Thanks for the undertaking and commitments to see these through to implementation. Not seeing anyone. We don't need to vote on the recommendations. We've done that already. We support them. With respect to chapters 16 and 20, I'd welcome a motion to conclude consideration. Do we have a mover? Deputy Chair Young moves. All agreed? That's carried. We'll now turn our attention to chapters 9, respectively, of the 2019 report, Volume 2, and the 2020 report, Volume 2, and I'll turn it over to the Provincial Auditor's Office.
The next 2 chapters on the agenda, both Chapter 9, report on the annual integrated audit results of the Victims Fund. We also provide an update in our 2021 report, Volume 2, Chapter 14. Our integrated audits found that the ministry complied with relevant authorities governing the fund, and the fund had reliable financial statements. In our 2019 chapter, we reported the ministry had implemented an outstanding recommendation around submitting claims for federal cost-sharing agreements within a reasonable time frame. We also made a new recommendation on page 65 that the Ministry of Justice and Attorney General Victims Fund prepare key supporting documents at the same time as it prepares its financial statements. Preparing key supporting documents at the same time as draft financial statements allows management to effectively review the financial statements for accuracy and completeness. It also reduces the time it takes to perform an audit. We continue to make this recommendation in our 2020 chapter. Our 2021 report, Volume 2, Chapter 14, provides a current year update. During the 2021 fiscal year, the ministry prepared key supporting documents for management's timely review and provided our office with key documents to support the fund's draft 2020-21 financial statements within agreed-upon deadlines. There were no material errors identified this year that previously delayed the timing of our audit work. The recommendation is now considered implemented. I will stop for the committee's consideration.
Thanks again for the presentation, the focus of the work, and the presentation. It's great to see implementation has occurred. I'll turn it over for a brief remark to Ms. Alexander, and then we'll take a question if there's any.
As the provincial auditor reported in its Chapter 14, 2021 report, Volume 2, that this recommendation is now fully implemented, we have no further comments on this particular chapter.
Thank you. We'll open it up if there's any questions. Ms. Ritchie.
Yes, thank you, Mr. Chair. I wonder if more information can be provided regarding the $1.9 million unauthorized money transfer?
Page that you can reference?
I believe it is page 64.
Could you just restate the question for everyone?
The question is, can we have some more information on the $1.9 million unauthorized money transfer? It's not clear to me, honestly, whether this is unauthorized or not, but I believe it is referring to the administration costs and bad debt on page 64.
Details before me, and I imagine Ms. Alexander's trying to find, but we do surmise that this was a few years ago as such, but we do think perhaps what it was an order in council that wasn't authorized probably by year end, and the Victims Fund would have recorded the revenue, assuming that they were entitled to it by March 31st, and then perhaps weren't and should have reversed, and then that was corrected and properly stated in the financial statements that were they issued. So they were reliable, but it was about the preparation and just the support behind what was provided for the purposes of the audit.
Okay, so it sounds like the issue has been resolved.
It is, yes.
Oh, right.
And then this past year's audit, there was no errors found with regards to and the support provided for the purposes of the financial statement audit. And so we are satisfied this recommendation has been implemented.
All right, thank you very much. No further questions, Mr. Chair.
Thank you. Any further questions from others around the table? So we have one new recommendation here in the first chapter there in the 2019 report, recommendation number 1, and it's been reported out that implementation has occurred. I'd welcome a motion that we concur in note compliance, moved by Mr. Friesen. All agreed? That's carried. And trying to keep up with the members' hands, cat-like reflexes on Friesen and Gowdy there. But all agreed, that's carried. And I just want to thank Ms. Alexander. I suspect, does this conclude your time with us at this table? Thank you so much for your service and for taking the lead here at this table, and thank you to all those that are involved in this very important work. So thank you for that, and with that, we'll take, how much time do we need to shift chairs around here? Just a couple minutes? 5 minutes. Okay, we'll take 5 minutes, and then we'll dig into the reports with corrections and public safety. Thank you. there, Mr. Skoropad. We're going to reconvene here this morning. The chair missed something here, and so just returning to the very last consideration. Of course, we voted on the recommendation, the new recommendation. We failed to pass a motion to conclude consideration of Chapter 9 in the 2020 report. Deputy Chair Young moves. All agreed? Agreed. All right. So we're moving along then to our considerations of the Ministry of Corrections, Policing and Public Safety. I want to thank Assistant Deputy Minister Scriver, thank you, for joining us here today. And I'll turn it over to Ms. Scriver to briefly introduce officials that are with her here today, and then we'll turn it over to the auditor. We'll come back to you for remarks on the subsequent chapters.
Thank you. Thank you very much, and it's a pleasure to be here today. I'd like to pass along regrets from Deputy Minister Larson, who cannot be here today, although I may not be as charismatic or as charming as him, but I'll try to represent as best I can. Before I introduce the folks who join me today, I'd like to thank the committee for the opportunity to be here, and to thank the Office of the Provincial Auditor for the good work they do. We appreciate the positive working relationship we have enjoyed with the Auditor's Office, and we certainly welcome these reports, which serve as a helpful guide for us to identify areas that we can improve on. A number of recommendations in these chapters in front of you have been implemented, and we will continue to make progress on those considered not fully implemented. Moving along to officials joining me here today, I have Mark McFadden, the Executive Director of Custody Services, Caroline Graves, Executive Director of Community Corrections, Dean Carey, Executive Director of Offender Services, Monica Field, Executive Director, Strategic Systems and Innovation, and Noel McNavina, Executive Director of the Provincial Disaster Assistance Program, and Aaron Orban, who is our Executive Director of Access and Privacy Branch. This concludes my opening comments, and we would be very happy to answer any questions the committee may have.
Thank you very much, ADM Scriver, and I will turn it over at this point to the Provincial Auditor's Office to focus on the first two chapters, Chapter 2 and Chapter 2 of the 2019-2020 reports, Volume 2, respectively.
So thank you, Mr. Chair. This morning with me is Mr. Jason Wandy, who will present the chapters related to the Ministry of Corrections, Policing and Public Safety in the order that they do appear on the agenda. He does plan to present the two first chapters together, and then the rest will all be separate. He will pause for the committee's deliberation and discussion after each presentation. There are 4 new recommendations for the committee's consideration, and I do want to thank the ministry officials for the cooperation that was extended to our office during the course of our work. I'll now turn it over to Jason.
The first two chapters, both Chapter 2 in our 2019 and 2020 reports, Volume 2, report on the annual integrated results of our audit of the Ministry of Corrections and Policing, now the Ministry of Corrections, Policing and Public Safety. We also provide an update from our 2021 report, Volume 2, Chapter 14, which provides a summary of implemented recommendations. Our integrated audits found the ministry had effective rules and procedures to safeguard public resources and complied with relevant authorities, though both chapters included a finding related to removing unneeded user access. The recommendation was first reported in 2015, and we provide updates in both the 2019 and 2020 chapters. We continue to recommend the Ministry of Corrections and Policing follow its established procedures for removing unneeded user access to its computer systems and data. Not removing unneeded user IT access promptly increases the risk of unauthorized access to IT systems and data, including confidential information, along with increased risk of inappropriate modifications to IT systems or data. We provide an update for 2021 in the Summary of Implemented Recommendations chapter included in our 2021 report, Volume 2, Chapter 14. In June 2021, the Ministry developed a timely removal from information technology systems policy, which outlines when the Ministry expects a user's access to be removed and defines what is considered timely removal, that is, within 3 business days of an employee's last day of work. We note the ministry is continuing to reduce the number and severity of instances of late user access removal. They continue to work with the Public Service Commission to receive notifications when staff leave the ministry. We do not consider the identified deviations to be significant, and we confirmed accounts were not inappropriately accessed after the users ceased employment with the ministry. We consider the intent of the recommendation implemented. I'll now stop for the committee's consideration.
Thanks for the presentation and the work. I'll turn it over to ADM Scriver for brief remarks and then open it up for questions.
Thank you. With respect to this recommendation, the provincial auditor reported in their 2021 report, Volume 2, Chapter 14, that this recommendation is now implemented. I have no further comments on this chapter, but I'm happy to take any questions from the committee.
Thank you, and thanks for the work on this front. I'll open it up for questions. Not seeing any. You know, this dates back a little ways, 2015, and there's clear, action here that's now implemented it. So that's pretty cut and dried. I would welcome a motion to conclude consideration of the two chapters, Chapter 2s respectively. Moved by Deputy Chair Young. All agreed? That's carried. I'll turn it back to the Provincial Auditor's Office for focus on Chapter 4.
Thank you, Mr. Chair. Extreme weather events can cause damage to property and infrastructure that can result in significant costs for infrastructure repair, such as roads and the property of those living and working in the disaster area. Generally, home and business insurance policies do not cover damage caused by natural disasters, such as earthquakes, landslides, and flooding. Consequently, government financial assistance can be a key resource for residents to recover and rebuild. Over the last 10 years, amounts of disaster assistance paid to claimants in Saskatchewan by the Provincial Disaster Assistance Program has fluctuated significantly from a low of less than $4 million in 2019-20 to a high of over $112 million in 2011-12. Chapter 4 of our 2021 report, Volume 1, reports the results of our audit of the Ministry of Corrections, Policing and Public Safety's Provincial Disaster Assistance Programs processes to provide timely financial disaster assistance. It includes 4 new recommendations for the committee's consideration. As of January 31st of 2021, the Ministry of Corrections, Policing and Public Safety had effective processes, other than the areas identified in our 4 recommendations, to provide timely financial disaster assistance under the Provincial Disaster Assistance Program and seek amounts reimbursable under the Federal Disaster Financial Assistance Arrangements. Our first recommendation can be found on page 24. We recommend the Ministry of Corrections, Policing and Public Safety set a service standard for how long it expects to take to assess requests for designation as disaster areas made under the Provincial Disaster Assistance Program. We found the ministry has not established a service standard for how long it should take to assess a disaster area designation. From our discussions with program staff and observing the designation process, we established a benchmark for testing of 1 week based on how long the designation process normally takes. Our testing found the ministry did not always complete its assessment of the requests for designation within 1 week and did not document reasons for delays in completing its assessment. Unclear expectations for reviewing request for designation increases the risk the ministry will not complete its review promptly. Delays in designating disaster areas results in delays for individuals and businesses applying for financial assistance, and thus recover and rebuild after a significant natural disaster event. Our second recommendation is on page 27. We recommend the Ministry of Corrections, Policing and Public Safety formalize its expectation about how often staff should determine the status of the completion of disaster assistance restoration work for claims under the Provincial Disaster Assistance Program. The ministry monitors the completion of restoration work for local authority claims as required under legislation. A municipality would be an example of a local authority. Under regulations, local authorities must complete restoration work within a year or obtain a letter granting an extension. Ministry management also expects that staff will follow up on progress of work being done every 2 months when disaster restoration work is taking place. Management has not formally documented or communicated this expectation to staff. Our testing of a sample of claim files found that ministry staff followed up with claimants at least annually to complete extension letters, but had not followed up on progress every 2 months as management expected. If staff are not following up as frequently as expected, local authority claims may not be finalized timely, resulting in delays in payments to those claimants. Delays in finalizing claims will also delay the ministry's claim for reimbursement to the federal government, as the ministry cannot submit its final claim until all eligible restoration work has been completed. Our third recommendation is on page 32. We recommend the Ministry of Corrections, Policing and Public Safety analyze actual results compared to expectations for key service standards for the Provincial Disaster Assistance Program and determine whether changes to the program are needed. Ministry staff report to senior management on several key program activities at least monthly. However, we found the ministry does not currently assess actual results for the program against management's expectations for key service standards. Our analysis found for 2 of 117 claims, contracted adjusters completed their assessment of damages after 51 and 71 days, which is longer than the 45-day benchmark set out in adjusters' contracts. Our analysis also found 1 of 93 private property claim payments made in the 2020 calendar year was paid after 99 days, outside the expected 90-day timeframe. The ministry had not identified these exceptions nor analyzed reasons for them to identify potential causes and actions needed to address them. Analyzing actual results compared to expectations helps management determine whether staff and contractors are meeting its expectations for timely assessment and payment of claims and whether it needs to take action. Our fourth recommendation is also on page 32. We recommend the Ministry of Corrections, Policing and Public Safety periodically report to senior management actual results against service standards, for example, 90 days for final payment for private property claims, for key activities of the Provincial Disaster Assistance Program, and the status of any complaints or appeals. Without regular reporting to senior management on the status of any complaints or appeals, and whether the program is meeting service standards for key activities, senior management may not be aware of potential issues within the program or take timely action to address issues. I'll now pause for the committee's consideration.
Thank you for the presentation, the focus of the work. I'll turn it over to ADM Scriver for remarks, then open it up for questions.
Thank you. For the first recommendation, an internal performance measure of 14 days has been developed to respond to a completed designation request from a local authority. This information will be included in training manuals and will be reported on quarterly to management. Regarding the second recommendation, an internal performance measure has been formalized for staff to be in contact once every 2 months with municipal claimants who have open claims. A process is being developed to track and report this correspondence. This formal measure will be incorporated into staff training manuals and will be monitored through regularly scheduled meetings with staff on open claims. This metric will also be reported quarterly to management. For the third recommendation, a review of metrics has been conducted for key internal and external areas of performance, with benchmark standards being established for all. These performance metrics will be reported to senior management quarterly. Where analysis of these metrics indicate deficiencies, management will consider appropriate actions if required. For the last recommendation, reports have been identified that can be run against the PDAP database. These results on key performance measures will be included in PDAP's regular monthly report. A quarterly report will be provided to senior management on key statistics and analysis of additional benchmarks, as well as the status of recent complaints or appeals. The ministry is expected to have all 4 recommendations implemented by the end of fiscal 2022. This concludes my comments on this chapter.
Okay. Thank you for that report, and thank you to all that are involved in this important work. At this point, I'll also table PAC 5129, Ministry of Corrections, Policing and Public Safety Status Update dated March 2nd, 2022. Thank you to all those folks that were involved in completing that status update. It really allows us to focus our efforts effectively around this table. I'll open it up for questions at this time. Ms. Ritchie.
Thank you, Mr. Chair. In sort of looking at the information in front of me here, I do have a couple questions regarding the uptake or the access for the federal funding. Do you have a sense right now of how these delays and the claimants coming forward in a timely fashion to make their claims and have them processed is affecting the utilization of those federal dollars?
It's Noel McVenna, the Executive Director for PDAC. As of right now, there's been no impact on the federal recovery. We've requested appropriate extensions from the federal government to obtain the permission to extend the claims in order to make sure the repairs are done and all federal dollars are captured.
Any sense of why those delays have been occurring and what's being done to address those issues?
So in terms of claims that are still ongoing and taking a significant amount of time, we're looking at municipal claims in that case. And specifically, claims that involve bridge projects tend to be the ones that take the longest because there's involvement from the Department of Fisheries and Oceans and permitting that has to be put in place before the repairs can be effected. Obviously, these are things that are beyond the scope of what our program can help with, but those are our longest standing claims.
Okay, thank you for that. No further questions, Mr. Chair.
Okay. Any further questions from folks around the table? Certainly, this is an important program, and communities, municipalities, people, businesses, farms, depend on it, rely on it. So thanks for those that are working to make sure that it's being administered in a timely way for folks. And thanks for the commitments to see these through to implementation. Any further questions? Not seeing any. I would, we can vote on these recommendations, 4 new recommendations, and I'd welcome a motion to concur and note progress with respect to the 4 recommendations before us. Moved by Deputy Chair Young. All agreed? All right, that's carried. We'll move along now to Chapter 25, and I'll turn it over to the Office of the Provincial Auditor.
Thank you. Chapter 25 of our 2020 report, Volume 2, reports the results of our 3rd follow-up of the audit we did on the Ministry of Corrections, Policing, and Public Safety's processes to rehabilitate adult offenders likely to repeat crimes, including serious or violent crimes, who were serving a community sentence in the Regina-Qu'Appelle region. We made 7 recommendations in the 2011 performance audit. There were still 4 outstanding recommendations, and by June 30th of 2020, the Ministry implemented 2 and partially implemented the other 2. Since 2017, the Ministry implemented 2 initiatives to promote and support the use of integrated case plans for adult offenders through information sharing among stakeholders, including public prosecutions, adult corrections, federal and municipal police services, and the Canadian Mental Health Association. We found Ministry staff had incorporated information from partners in their risk assessments and had engaged with partners to support planned actions and tasks to support rehabilitation. The Ministry also revised its risk assessment, case management, and supervision policies in 2019 based on consultation with criminal justice stakeholders and review of standards used in other provinces. Compliance audits completed by the Ministry found 47% and 57% of staff complied with the Ministry's revised supervision policy. In response to the results, the Ministry's Workload Review Governance Committee expects to establish targets for compliance with the Ministry's policies once it implements the revised risk assessment and case management policies. Establishment of targets would help the Ministry take timely and appropriate corrective action where staff do not follow policies as expected and reduce the risk of not effectively rehabilitating offenders. I will now pause for the committee's consideration.
Thank you very much for the follow-up on this front, the focus on this front. I'll turn it over to ADM Scriver for brief remarks and then open it up for questions.
For the first
recommendation, which is considered implemented, as well as the third recommendation with the intent of the recommendation implemented, the ministry concurs with the auditor. Regarding both recommendations that are considered partially implemented in the report, the ministry implemented revised intake and assessment and case management policies on October 15th, 2020. To monitor compliance, an audit methodology, data collection, and reporting procedures have also been developed and continue to be validated and revised as needed. The ministry will establish compliance targets for its assessment and case management policy through the review of the compliance audit results. Targets will be established for both outstanding recommendations in spring 2022.
Thank you for the report and the timelines and the actions you've laid out. I'll open up to members for questions. Ms. Ritchie.
Thank you, Mr. Chair. So I did kind of pick up on the percentage rate that was listed in the auditor's presentation of, I think it was 44 or 47%, I believe. And I guess that's a bit concerning. It does sound as though staff workloads, I'm wondering if staff works could be impacting the ability of those staff members to effectively monitor offenders on release. Can you tell us more about what's being done to address the issue?
Good morning. My name is Caroline Graves. I'm the Executive Director of Community Corrections. Thank you for your question. I'm happy to explain what we've done recently. So in 2017, Community Corrections began a large-scale workload review focused on probation officer and community youth worker positions. The review resulted in a number of changes. And I spoke about this the last time we were in public accounts. We were about to proceed with that work. So for instance, changes were made to supervision standards. A revised policy was implemented in December of 2019. And then during the response to COVID-19, when client reporting was at times not in person, client contact was measured on an ongoing basis. We've returned to normal reporting requirements and are resuming auditing compliance with supervision standards. And the status of the recommendation requiring that the ministry consistently follow its supervision policy for high-risk adult offenders in the community to have required contacts with probation officers or alternates is considered to have been implemented in terms of intent. So we've made some really good progress in that area in terms of supervision standards. And then in addition to that, the ministry's also made changes to the risk assessment and the case management policies, which are also key elements of the work done by probation officers and community youth workers. So although the plan was to implement the changes in those policies in the spring of 2020, with COVID, we were a bit delayed. So the changes were implemented in October of 2020. And the changes that we made involved a great deal of consultation with a number of stakeholders, both internal and external. We involved frontline employees in that work as well. And at present, we continue to monitor where we're at in terms of completion of risk assessments and case plans. We've made some great progress, and I'll talk about that in a minute. We've developed some audit methodology, data collection, and reporting procedures that we continue to refine as we move forward. As it relates to completion of progress reports, as a result of the workload review changes, this information is now contained within the case plan documents, and the auditing process for that requires more of a manual process to determine where we're at, and that's currently being finalized. So right now in the spring of this year, we're finalizing our targets for completion of risk assessments and case plans. In the last number of months, when we go back and look at the data as to where we're at, when we look at what we're completing within the timelines that we've made the changes for, and the what we're completing slightly outside of those timelines, we're at about 75%. So we're continuing as we move forward to make some modifications.
How many caseworkers does the ministry employ on a permanent or temporary basis, and what are their caseloads?
We have approximately 244 full-time equivalent positions. At any given time, unfortunately, we're staffed with vacancies and turnover as well, which is an ongoing challenge for us, and we do the best we can to staff our positions as quickly as we possibly can. But there's about 244 staff that would be involved in doing the case management work on a daily basis. In terms of the caseloads, the sizes vary, and we have it depends on the location, it depends on the type of caseload, but I can take you through some examples. So if we look at our provincial rural caseloads, so it looks slightly different than our urban offices. The service delivery model is set up slightly differently. In terms of the provincial average rural caseload for adult and youth combined, our average is 41. And the average urban caseload for adult and youth combined is 38. And then in our Saskatoon, Prince Albert, and Regina offices, we're set up slightly different in terms of how we deliver services. We have intake and assessment units and case management units. In the intake and assessment units, provincially, our average is 28 adult clients and 13 youth clients. As it relates to the average urban caseload, it's 55 adult clients and 17 youth clients. And then in addition to that, we also have some specific targeted caseloads. So for example, we have the serious violent offender response in a number of our locations. So in Regina, Saskatoon, North Battleford, and then in 3 northern communities of Sandy Bay, Pelican Narrows, and Deschambault Lake. And those caseloads would be at a maximum of 15. You work very intensely with those clients, and we have a number of those types of caseloads as well. So that the number of average cases, it kind of all depends. But hopefully that helps.
You mentioned vacancy rates. Where is that currently sitting?
At present, we have, in terms of our probation officer and community youth work positions, community youth worker positions in our central region, we have 3 different regions, central, south, and north. In the central region, there's 7 vacancies presently. In the north region, there's 15. And in the south, there's 2. And it varies from day to day.
How long does it take normally for a position to be filled? Like, how long would a position be vacant for?
It's a good question. It would all vary depending on the circumstance. I would say, generally speaking, 2 to 3 months to staff a position. By the time you post it, wait for the applications to come in, screen the applications, do the interviews. But it can sometimes be a little bit more challenging than that in the sense that we may staff it or try to advertise a position, and then we may not get successful applicants, and we may have to at times re-advertise.
Do you ever delay or defer, or is that an immediate turnaround?
As soon as we have vacancies, we proceed to staff.
And do you track that through your management systems and dashboards?
We do. We track that all the time. Yeah.
Great. Thank you very much.
Not seeing any further questions. At this point in time, I would welcome a motion to conclude consideration of Chapter 25. Moved by Deputy Chair Young. All agreed? That's carried. We'll move along, turn our attention to Chapter 26, and I'll turn it back to the Provincial Auditor's Office.
Thank you. Chapter 26 of our 2020 report, Volume 2, reports the results of our second follow-up of the Ministry of Corrections, Policing and Public Safety's actions on recommendations we first made in 2016 on planning for inmate capacity in correctional facilities. Our audit found that at July 31st, 2021, the 3 remaining recommendations are now implemented. The Ministry has finalized its adult custody long-term capacity plan for strategic planning at its correctional facilities. The plan includes definitions for operational capacity and ideal program space. Having a written long-term plan to manage inmate capacity in adult correctional facilities is important to inform ministry decision-making and determine the correct space to provide adequate housing and rehabilitation programs for adult inmates. I'll now pause for the committee's consideration.
Thank you for the follow-up on this front. Of course, this has been considered at this table before. If there's any brief remarks from ADM Scriver, that's great, and then we'll see if there's questions.
As all 3 recommendations are now considered implemented, I have no further comments.
What a report. I'll open it up now for questions.
Thank you. May I?
Ms. Ritchie.
Sorry, jumping the gun there a little bit. Yes, sorry about that. Well, things are moving along at a quick pace here. I did have one question. Under 3.1, can officials speak to the adult custody long-term capacity plan and how it is helping to provide adequate housing and rehabilitation programs for adult inmates?
Mark McFadden, Executive Director of Custody Services. So what the development of the long-term plan has allowed us to do, it's allowed us to focus both on capital initiatives and non-capital initiatives. Both initiatives assist us in identifying appropriate living conditions for our offenders. So if we have to look at extra infrastructure, we'll deal with our capacity planning division. We'll share the report with them, which we have already in future plans that we have, and are trending for bed space to identify how many beds we might need in the future. In regards to the non-capital initiatives, it helps identify initiatives that we have underway in regards to like reintegration planning, so that we can identify how many beds we have in our facility, the trends that we may have, and may have to examine reintegration leaves for offenders both out of our facilities proper or out of our reduced custody facilities.
When you talk about sort of the needs of the adults, can you elaborate a little bit on what that might look like?
Some of their programming needs in particular. Part of our long-term plan was to identify programming space that we'd be requiring in our facilities to focus on programming and get offenders in the appropriate programming so that they can address their risk needs to assist in their better reintegration into the community. We've done that as part of our long-term plan. I know that we spoke to it in regards to the one recommendation. We've identified how many programming spaces ideally that we would require today, and then also in future builds, how many programming spaces we would require on a offender ratio to program facilitator ratio.
Apologies that not knowing sort of enough about what program needs would be. Could you, again, just further elaborate on what would be necessary for reintegration?
Certainly can. In regards to identifying programming needs, so when an offender is sentenced to an incarceration sentence, they will sit down with the case manager. They'll go through their case plan based on both historical information and information that was brought on the current offenses. It'll identify certain risks that the offender presents in reoffending. They'll try to align those risk and needs up to appropriate programming in the facility and or outside of the facility in a reduced custody facility. And the offenders will attend programming when available and when offered in the facility. And once the programming is completed, it assists them then in their reintegration planning, applying for reintegration leaves into the community. They've addressed some of the risk and needs that were identified both through them and through their case manager, which will lead to their success and also success in getting a reintegration leave back into the community.
So maybe you could provide a couple examples.
Of programming? Dean? I can. Dean is the Executive Director of Offender Services, so he'd be able to speak to programming a lot better than I can, but I certainly can. So I'll speak to a couple, and Dean can fill in the blanks for sure. Programming there's programming proper, as most people think of programming. An offender goes to a program on whether it be domestic violence or addictions, whether it be alcohol or drugs. There's also programs of employment. There's programs of work readiness. Programs of, what are some other examples, Dean? Cognitive thinking programs that we, depending on the risk needs of the offender, will line them up with.
Yeah, a lot of the cognitive behavioral programs are really around skill building. So we find that a lot of our clients, the individuals, lack social skills, problem-solving skills, basic life skills. A lot of the work in standardized programming is to provide them with those. And then thinking skills, to actually work with them to really develop new ways of thinking about situations, so that they then may be less aggressive, less angry. They may think of pro-social ways to deal with things versus, to date, what has got them involved with us in terms of how they respond and how they behave to certain situations. So we do try to provide a variety of different programs, addictions programs as well. The addictions program, we do also have a criminogenic component to it, so that we address both their addictions issues as well as some of the issues that would have led them to committing crime as well.
And so I'm wondering, that's very helpful. Thank you very much for that further explanation. I just wanted to ask about, budgetary provisions for these types of programs, and how well you're able to sort of match up those needs through delivery and budgetary allotments.
Sure, I can speak a little bit to that as well as Dean and Mark probably can as well. We have partnerships with the SHA. We have contracts with public health. We bring them in as service providers to our facilities when we can. We know that we cannot be everything to everybody, so we rely on the Elizabeth Fry Society or the John Howard Society, the Saskatoon Tribal Council, to assist us in delivering programs to our clients. And it's not, we have a lot of people that really, really want to help us out, and we do capitalize on that when we can. In terms of budgets for our programs are budgeted. It's all part of our annual submissions, and if we see there is a program that we're interested in and it's evidence-based and there's a great work plan and we have the data to back it up, we will submit our budget documents to see if we can facilitate those programs.
One of the things I would add as well is that certainly all of our sentenced clients, individuals, a risk assessment's done is to basically inform their case plan. Their case plan will have interventions. The interventions are the programs themselves. Average length of custody sentence at this point is less than 10 months. So in terms of, we want to ensure that the clients have a program as part of their time spent with us, because it will impact whether or not likely they will come back or be further involved with the law. So we do try to be strategic about which program and when they enter the programs, in that we really are time limited as well in terms of what they're able to accomplish while they're with us.
Thank you very much. I appreciate those answers.
Okay, thank you. Thank you for the responses and the work on these fronts. Any other questions? Mr. Nerline.
Yes, thank you. With respect to recidivism, does a person who is re-engaged in the system, do they have a continuous programming that they can be in terms of sort of going from one step to the next? So if, let's say they're out for a year, come back in, out for 6 months, come back in, and so on. Are they flagged in terms of what they have been involved in, engaged in, and then how does that proceed from step to step going forward?
We would have a record. We certainly track what they've been involved in and what they've accomplished. We would also have information as to how well they did in the program. In some cases, it might make sense, not necessarily that they would complete, but that there would be some follow-up work done with them. One of the pieces that we've been really working towards doing is ensuring that all of the individuals who are involved with us have a relapse, call it a relapse prevention plan. So it identifies what the factors are, the high-risk factors. It gives them some strategies to potentially do something different, so that if they have that, because often they've never had that before, in terms of how they might think about something, how they can escape or exit a situation. And so a lot of it is then being able to go back and talk with them about, so when this happened, did you do this? And sometimes it's about going back, talking about it, encouraging them to use the strategies that they have, get them to think about what they could do differently next time so that hopefully they don't come back again.
Not seeing any other questions at this time. Actually, Mr. Skoropat has a question.
Yes, thank you, Mr. Chair. I just have a real quick question, just about, you mentioned about, the working with the caseworker and the determination of the programming that takes place. I wonder if you could just comment on the collaborative nature of how that happens, because we know it's so important for buy-in of the offender. Just if you could just make a brief comment on that.
Certainly. So one of the first pieces is around completing a risk assessment, which is done with the client and reviewing their file. And then it's then sitting down with the individual and talking about the outcome of the assessment. And that would clearly identify the areas that they should really be working on while they're with us, in order to, for instance, get a reintegration leave or move to a reintegration unit, or and so it really is a collaborative process in terms of building that case plan and prioritizing what it is that they should be working on. Part of that too is just to get buy-in from them, right? Like, if you do this, then this is a possibility. And so that's what we try to do. Yeah.
Thank you. Thanks so much. Good question. Thanks so much for the time with us here today on this chapter. Not seeing any other questions at this point. These recommendations have been dealt with by this committee. I'd welcome a motion to conclude consideration of Chapter 26. Moved by Mr. Friesen. Did I see your hand, Mr. Friesen? That's good. All agreed? That's carried, and we'll move along to Chapter 27, and I'll turn it back to the Provincial Auditor's Office.
Thank you. Primary medical care received in a correctional center can play a role in reducing health inequity for vulnerable inmates. Chapter 27 of our 2020 report, Volume 2, reports the results of our first follow-up audit on the 9 recommendations we made in 2018 on the Ministry of Corrections, Policing, and Public Safety's processes for the provision of primary medical care to adult inmates in its secure custody correctional centers. By July 2020, the Ministry had implemented 2 recommendations and made progress on some of the others. The Ministry developed new policies and updated existing policies to address gaps in medical care policies. Correctional centers reviewed and updated medical care directives and developed directives to address gaps. The Ministry also made progress on developing training for nurse managers, which it planned to deliver in 2020-21. It also developed a new form to facilitate transferring key medical information when inmates move between correctional centers, which the correctional centers were starting to use. Correctional centers made progress on tracking first aid certifications and reporting to the Ministry on the currency of certification. However, we found that they did not do this accurately. For 3 out of 30 employees we tested, the certification expiry date on the tracking sheet did not match the actual expiry date on the certificate. The ministry updated its policy on complaints to require correctional centers to track, respond to, and analyze inmate medical care complaints timely. Correctional centers need to respond to complaints timely and provide the ministry with a complete analysis of trends and corrective action taken. We also note the ministry had not yet developed measures for evaluating the provision of medical care to inmates, nor had it started receiving regular reports from correctional centers on the provision of medical care to inmates. Without this information, the ministry does not know whether inmates receive care consistent with its policy, and the medical units in correctional centers cannot identify areas of medical care they could improve. I will now pause for the committee's consideration.
Thanks again for the follow-up on this front and the presentation. I'll turn it over to ADM Scriver for a brief report. Thanks for the status update showing all the actions, and then we'll see what we have for questions.
Thank you. The provincial auditor has noted 2 of the recommendations are now implemented, so my comments will focus on the remaining recommendations. For the recommendation regarding delivering orientation training for the nurse manager positions in adult secure custody correctional centers, the nurse manager orientation training is incorporated into initial employment training and learning modules. 2 nurse managers have completed the orientation training. 1 new nurse manager is expected to complete training within the 5-month probationary period. Our 1 nurse manager position is currently vacant. For the recommendation regarding monitoring the currency of first aid certification of correctional staff from adult secure correctional centers, the ministry has implemented processes to monitor the currency of first aid certification. Correctional centers keep an ongoing tracking of certification and expiry dates and schedule recertification training sessions multiple times per year. Correctional center management reports staff completed outstanding certifications and plans for recertifications to central office every September. For the recommendation regarding requiring staff to transfer inmate medical files between adult secure custody correctional centers when it moves inmates between centers or former inmates re-enter the system, on December 9th, 2021, correctional center nurse managers were reminded of the requirement to use the improved transfer form consistently. Nurse manager medical file audits were implemented in October 2020 and include review of the most recent transfer form to ensure consistent use. Regarding the recommendation to formally respond to adult inmate complaints about medical care within timeframes required by the Correctional Services Regulations 2013, a formal tracking mechanism has been implemented to ensure complaints are responded to in compliance with policy and legislation. Direction has been provided to correctional center nurse managers that every effort should be made to respond to complaints on time, or, if unable, a letter of extension is sent to the inmate. Regarding the recommendations to analyze complaints about medical care from adult inmates in its secure custody correctional centers for trends and take corrective actions as needed, each correctional center tracks and reports on responses to medical complaints quarterly. These reports to central office now include actions taken to resolve each complaint. For the recommendation to work with adult secure custody correctional centers to develop measures for evaluating the provision of medical care to inmates, correctional center nurse managers began conducting medical file audits in October 2020, which include measures to identify and address gaps in the provision of health services. Regarding the recommendation to receive regular reports from adult secure custody correctional centers on the provision of medical care to inmates, medical file audits include measures to identify and address gaps in the provision of health services. Nurse manager medical file audits, quarterly complaint summary reports, and appeal referrals are referred for potential areas of improvement. An electronic health system which would expedite this process, and it continues to be explored. That concludes my comments.
Thanks for the comments. Thanks for all the work. I'll open it up to committee members for questions. Ms. Ritchie?
Thank you, Mr. Chair. I believe I heard you say that currently you have 1 vacancy in your nurse manager positions. And I wanted to ask about turnover within your staff complement there. What sort of frequency is that occurring on? And what sort of historical trends have you seen so far in terms of those vacancies and how they've trended over time?
Morning. Dean Carey, Executive Director of Offender Services. Certainly, nurse manager positions and nursing positions have had issues around turnover, and they have been hard to maintain, certainly. So what we will do is have acting nurse managers while we're going through the process of hiring permanently for those positions. We would also then afford those acting nurse managers the same training that we would provide a permanent nurse manager. Certainly, we endeavor to try and retain them as much as we can.
Any insights or understanding onto the reasons for those turnovers?
I think that it's certainly a challenging job, and COVID and the pandemic has certainly just exacerbated all of that. And I think that, to some degree, it does become a challenge, but we certainly are always in the process of. We have another advertisement for a permanent nurse at Pine Grove, currently which is the vacant position that Heather mentioned. I think, making sure that they have the proper training will assist with retaining them. And I'm hoping that we're going to be able to work through this pandemic and we have a little bit more stability across all.
So has the ministry undertaken any sort of an evaluation to understand the factors that are creating a challenging situation and what's being done in response?
We do know that the compensation, of course, is an issue with retaining some of our nurses. So if we were to do an exit interview on our nurses, the compensation appears to be more attractive with the health authorities than with the collective bargaining agreement that we abide by right now.
So these manager positions are in scope?
No, the manager positions are out of scope. I'm talking about the vacancies and the turnover that we would have with our in-scope nurses that we have at the correctional facilities as well.
I see. So you mentioned compensation. Are there other sort of other factors that have been identified?
Not that I'm aware of. I mean, to work in center is a different type of nursing experience, but certainly we've had some people long-standing and who really enjoy what they do. I would just quickly mention, we have opened up a licensed practical nursing position to assist in terms of ensuring that we have adequate nursing within the facilities. We will just continue to work with that and ensure that we're able to offer what's required in order to maintain those positions.
I wanted to also ask about status update notes that each correctional center is required to track all inmate complaints. And I'm curious if you have any stats on how complaints have been received annually.
The stats somewhere. I brought them. If I had to, from what I remember reading, was about 300 for the year, and then in terms of then responded to. Sorry, 129.
Thank you for that answer. And I wondered if I could also ask for details on the October 2020 review of the provision of medical services to inmates.
Are you referring to the nurse manager medical file audits that were implemented in 2020? I don't.
Perhaps. Maybe we'll assume so. Okay. The nurse.
And are ongoing, and are reported up to central office to the health services team. The health services team meets monthly with health services within center, so with the nurse manager and the deputy director of standard communication, who the nurse manager reports to ensure that any trends or concerns are addressed in order to try to make sure that we're meeting policy and legislation.
Very much for those answers. Appreciate it. Oh, I'm sorry. No further questions, Mr. Chair.
Just looking around the table here, any further questions from others with respect to Chapter 27? Thanks for the report. Thanks for all the work. Thanks for your time on Chapter 27. At this point, I would welcome a motion to conclude consideration of Chapter 27. Moved by Deputy Chair Young. All agreed? That's carried. We'll move along to the last chapter on our agenda before lunch, which always keeps consideration kind of condensed. No rush though, folks, but I'm hungry. And I'll turn it back over to the provincial auditor.
Chapter 20 of our 2021 report, Volume 2, reports the results of our 5th follow-up of the audit we did on the Ministry of Corrections, Policing, and Public Safety's processes to rehabilitate adult inmates. Research indicates that inmates receiving treatment in rehabilitation programs have lower reoffending rates than offenders who do not receive treatment. Rehabilitated inmates gain more opportunities to return to work and contribute to their community. We made 4 recommendations in the 2008 performance audit. At the time of our follow-up, there were 3 outstanding recommendations. By March 2021, the ministry had implemented 1 of the recommendations and continued to work on the remaining 2. The ministry routinely uses information about the number of inmates accessing or waitlisted for programs in each correctional facility to identify potential program enhancements using reports it has created in its Criminal Justice Information Management System. Monitoring inmates' access to rehabilitation programs will allow the ministry to make necessary adjustments to enhance inmates' access to programs. While the ministry now monitors inmate reoffense rates, at the time of our follow-up, the ministry had not used the improved reporting to monitor and evaluate the rehabilitation programs to assess whether they help to reduce recidivism. Without evaluating correctional center rehabilitation program success in reducing inmate reoffenses, the risk of rehabilitation programs not meeting inmates' needs increases and reduces inmates' successful re-entry into society. The ministry's case management policy requires correctional staff to complete an assessment of a sentenced inmate's risk and needs within 28 days of their admission to a secure custody facility. Our testing of 30 inmate case files found that for 5 inmates, the assessment had been completed between 7 and 61 days later than the policy expected. For these 5 case files, we noted the COVID-19 pandemic had played a role in the timing of the assessments, but was not the only factor to cause delays. Not assessing sentenced inmates' rehabilitation needs within a reasonable time frame from their admission delays their participation in rehabilitation programming designed to reduce inmate reoffenses and address their needs. That concludes my presentation.
Thank you very much for the follow-up on this front and that presentation. I'll turn it over to ADM Scriber for some brief remarks and then get at the questioning.
Regarding the recommendation to monitor the proportion of inmates accessing planned rehabilitation programs before the inmates are released into the community and enhance access to rehabilitation if required, the ministry agrees with the auditor that this is now implemented. For the recommendation regarding monitoring reoffending rates in relation to rehabilitative programs to better evaluate its rehabilitation of inmates, the ministry agrees with the provincial auditor that this is partially implemented. As noted in the provincial auditor report, while good progress has been made in the ministry's ability to use data to monitor program outcomes, continued work to leverage its improved reporting to monitor and evaluate rehabilitative programs delivered in adult custody will contribute to more effective rehabilitation. A systemic annual review of programs to determine program evaluation needs in order to prioritize evaluation efforts within the existing resources is under development, which will inform an overall rehabilitative program evaluation plan. For the recommendation regarding consistently complying with the ministry's policy to assess inmates' needs, primary and secondary, and plan relevant programs, the ministry agrees that this is partially implemented. As noted by the provincial auditor, the ministry is consistently assessing inmate needs and identifying relevant rehabilitative programming based on these needs. However, delays are sometimes encountered with completing these activities within the 28 day of admission into custody. The ministry will review its provincial policy timeline standards to determine whether modifications are required. The ministry will also develop provincial standards for identifying and responding to overdue case management activities. The ministry will also continue to leverage daily case management reports to notify frontline case managers, supervisors, and different levels of management of overdue or absent case management activities for follow-up. This concludes my comments on this chapter.
Thank you for the report on the work that's currently underway and the timelines for implementation. I would open it up to the table for questions. Ms. Ritchie.
No questions at this time. Thank you.
I'm not that hungry. We can take the time we need if there's... Mr. Gowdy.
Yeah, just wondering, how effective are those rehabilitation programs? Like, do you track those who aren't included? I guess it'd be tough. The ones that you expect to have changes go into the program, and those others may not. But do you have any way of tracking the effectiveness of those involved in the rehabilitation programs we have?
Sure, yeah. So we have done evaluations, and generally when we implement a program, we would undergo a literature review to try to, I mean, there are lots of different programs out there. Lots of different places have tried a number of different things, and they've evaluated to see if it's effective or not. And so we have really, our goal has been to implement effective programs from other jurisdictions in many cases, and then we've attempted to evaluate them within our own jurisdiction in order to see if it's effective here, and is it effective with our population? Might be a different population than say in Ontario or British Columbia, and for the most part they are and have been. So within the correctional literature, they would suggest that a program is effective if it reduces recidivism 20 to 30%. And certainly our programs that we have evaluated do that. And so, I mean, I think that what we've talked about doing, we've recently hired a director of program integrity and evaluation who's creating the program evaluation framework that Heather referenced. And, we will clearly lay out for the auditor as well in terms of a schedule and a prioritization of which programs we will evaluate. It's a lot of work to evaluate a program to ensure that the methodology is sound, and so you're actually evaluating what it is that you need to evaluate. And we'll set out a 5-year plan. Our endeavor will be to evaluate all of our programs. And if something isn't working, then we will implement a different program.
then it's got to be tough to have comparables, like, you know, because you really, it's a tough, you're up against a tough thing there.
Right. So, but as you said, what we will do is we try to match individuals based on a variety of different factors, including risk assessments and other things. We can develop a control group, so those that haven't had any programming versus those that have had and have gone through different programs, and then we can compare and look at things like recidivism. And normally, the majority of the time, what we find is that those that have actually engaged in programming is to some degree wanting to engage and change versus those that are saying, not interested, I'll just do my time. There is a difference between those two groups. And the ones that do engage are more successful in terms of not coming back than those that haven't engaged in anything. Yeah. Well, thank you.
The questions, Deputy Chair Young also has a question, I believe.
There is an addictions and dedicated substance abuse treatment unit that's been operating in the Regina Correctional Center, and I know this might be too early, but just recently in 2021, because of the wait list that was identified at the Pine Grove Correctional Center, you implemented that same program there. And looking to expand it into the other correctional centers. So obviously it means you've had some success with it, or do you have any data that you can share with us at this point in time that shows that this is something that is working within the programs that you're offering?
Certainly. So the dedicated substance abuse treatment program that was originally, it was the partnership with the SHA in Regina, was thoroughly evaluated. And it did demonstrate around a 30% reduction rate in recidivism. And so with the gang violence reduction strategy, so it was federal dollars, we were able to replicate it at Pine Grove, as you mentioned. And what we did with that one was we contracted with Galvanizing Equity to ensure that it was both gender responsive and trauma informed, because the program was for women. But we tried to maintain the structure of the program because it was evaluated as being effective. We've also replicated that at Prince Albert Correctional Center, so that's now up and running. So again, we can then offer that program at another center. And for the Saskatoon Correctional Center, which is the last one, we will have a program up and running there as of April 1st.
And have you had trouble staffing those programs?
No, they're all partnerships. So the SHA is a partner, and they provide the addictions counselors. And so between the addictions counselors and our staff, we co-facilitate those programs. We have a dedicated unit in order to do it, so that when individuals go into the program, they go into a dedicated unit. They basically kind of live and breathe addictions programming and criminogenic programming. And to date, it's been very successful.
Thank you.
Yeah.
Not seeing any further questions. Just thank you to everyone that's involved in this really important work, and it changes the course of many lives for the better, and that's better for our community, and for someone, for that person and their family, and certainly for the province. And so we wish you well with the work ahead. Thanks for the reports here today. Thank you, ADM, Scriver, and officials for your time. And like I wanted to say, thank you to all those that are involved in this work day in, day out, all across Saskatchewan. At this point in time, we'll recess, and we should conclude considerations so we don't bring you back after lunch. But I would welcome a motion to conclude consideration of Chapter 20, moved by Mr. Kirsch. All agreed? Agreed. Okay, that's carried. We'll take a recess for lunch and be back here at 1:15 with the Ministry of Social Services.